Good afternoon, everyone. Welcome to the Appellate Division First Department, or arguments for today, April 11th. So this says that there are over 6 hours of our oral argument time requested. Fine with me. I have no plans this evening until 9 o'clock, so I'm good. So again, please, only ask for the time that you actually need to get out your salient arguments. We are fully familiar with your briefs. We understand your arguments. We know your arguments. We know the facts. So please, only ask for the time that you actually need to get out those salient points. Okay? People v. Raheem Barnes. That matter is submitted. Carlson versus New York City Council. Certainly. 5, 2, and 5. Matter of Shine Bliss. That matter is submitted. Willinsky versus Burkowitz.
Good afternoon, Your Honor. 5 minutes.
6 and 2 and 5. Rabach versus the City of New York. Appellant. I'm sorry, 1 second. Just for the appellant can go first. Now respondent. I'm sorry? Do you have a cross appeal? No. Okay, so 5, 2, and 5. Agard versus the Port Authority of New York and New Jersey.
For appellant, Island Diversified, 4 and 2.
Five, I'm sorry, 5 and 2. You have a cross, Island has a cross appeal? Okay, so then, you're the primary? Okay, so they're not here. Okay, so 5, 4, and 2, and 5. Brown v. Riverside Church.
For the appellant, 6 and 2, Your Honor.
5, 2, 5. People v. Stephen Pittz.
Appellant requests
5, 2, 5. 900 8th Avenue versus New York State Division of Housing.
Appellant, 4 and 2, please.
4, 2, 4. People v. Marcus Hesseram.
Yes, for appellant, 8 and 2. Responded, 5, please.
6, 2, 5. Fenn v. Langer. 5, 2, 5. Oper Plaza v. Wang. To be admitted, I'm sorry, Pro Hot VC? Yeah. Oh, okay, great. And the respondent? Yes, 626, thank you. People v. Marie Vasquez. 513. Star Indemnity versus Monte Carlo.
Appellant, 8 and 2, please. Responded, 6, please.
726. Liu v. Chang. That matter is submitted. Morris Perry versus Morris Perry. That matter is submitted. Abrams v. Abrams. That matter is submitted. First case for argument, Carlson versus the New York City Council. Yes, whenever you're ready.
Good afternoon, Your Honors, and may it please the Court. I'm Alan Racinas, and I represent the appellants. Your Honors, Supreme Court's order should be reversed for two reasons. First, under SECRA, Type 1 actions and unlisted actions are subject to the same analysis.
There's a presumption when it comes to the type 1, correct?
That's true, Your Honor, yes.
And what's the effect of not applying that presumption to your analysis?
I think, Your Honor, in this case, the effect is basically nil, and the reason is that there was an extremely detailed 144-page study done here that went through all of the relevant criteria. And
Had it been properly categorized, would you have done anything differently?
not that I could think of, Your Honor. I mean, that's that's our main point, as you know. I mean, the point is the analysis was extremely detailed. It was extremely data intensive, and that's what's required. What's required is the agency take a hard look as to whether or not there will be significant environmental impacts, and that's what the agency did here. It found that there would be basically no significant, basically very little environmental impact at all. So, in light of the specificity and the rigor of the analysis, combined with the fact that the determination ultimately was that there would be very minimal environmental effects, we think that presumption, to the extent that it wasn't followed technically, the effects were still as if the presumption had been applied. And I think that the other thing worth noting, Your Honors, is that the agency used the SECR technical manual, which is the City Environmental Quality Review technical manual.
Counsel, when you say take a hard look, what does that process entail?
Well, I think, Your Honor, it means not being cursory. It means looking very carefully at quantifiable information in each category that's pertinent to the analysis. So, for instance, like what the agency did here was it looked at when it came to wastewater. It used the SECR manual's equation to calculate how much wastewater would be generated, found that it would be about 12,000 gallons a day generated by the school, that is, once it was up and running, and determined that based on the capacity of a nearby wastewater treatment plant, that would have, which had something like, I think, 25 million gallons capacity to treat per day, that would have a minimal effect on that plant. That's the kind of analysis that has to be done. It can't just be looking at it and saying, well, we think there's not going to be a major problem here. You have to look at the agency has to employ as hard data as it can get, or at least that's what it did here.
What type of hard data did you use to look at the effects of traffic?
Yes, Your Honor. So what the agency did was it looked at, I think, 7 intersections in the vicinity of the school, determined that there needed to be some, based on and it did it when school was in session in April of I think 2021. It also accounted for the possible effects of lingering COVID effects, which is to say things weren't necessarily at full capacity still back then. So it looked at that. It determined that there were several minor changes that needed to be put into place to make the traffic continue to flow properly, including adding one stoplight and a few other minor changes. And it's also worth noting, Your Honors, that it employed its discretion under the SECR technical manual to determine which intersections were particularly pertinent to the analysis.
So when you're looking at traffic, you said you're looking at traffic during school hours. You're also looking, I'm assuming you're talking about drop-off or the morning, and then you're talking about the afternoon. That's when you're looking at the parking?
Yes, Your Honor, that's right. And and parking was studied along with traffic patterns, Your Honor, and what they looked at was, what the agency found was, I think there was something like 32 open parking spaces regularly in the vicinity right now, and looked at exactly who among staff and students would be taking.
And we're looking at an alternate side, right? We're looking at an alternate side of the street parking as well in that area?
I think so, Your Honor. I don't remember that particularly showing up, but I think that the bottom line, Your Honor, is that what they did was they looked and they saw that there would still be, even with the additional parking that would be needed, because of course some people would take public transport, some would be walking, et cetera. but there would be some additional cars.
Well, there are a lot of considerations because some folks also drop off their cars at that location and then take the train, which is another issue. But another issue, did you look at noise? Because I think that that was one of the main concerns by the petitioners was the noise and the level of noise in the area because of the school.
Yes, Your Honor, they were looking at noise. They didn't really find a major effect from that, I don't think. I mean, you wouldn't have noise except for when children were at recess, but I don't.
Well, I mean, you may also have noise, I don't know the definition of noise, but you may have more conversations because you're going to have more individuals. You're going to have more children. You're going to have children, and then you're going to have the individuals with whom they are with. So.
Sure, Justice Weber, I agree. I mean, I agree with you. I think but most of the day you're going to have people inside the building. I guess the question is, you know, when they're outside the building, how much additional noise is there going to be? And
Yes.
there wasn't, since there would be a very much additional noise. And just to,
Yeah, so you have time on rebuttal.
okay, Your Honor, go ahead. Thank you.
Good afternoon, Your Honors. Please the court. My name is Christina Carlson, and I am one of the petitioner respondents in this case. Petitioners
I
want
have a question. The
Yes.
Supreme Court not only agreed with you, but directed, I think it says directed the respondents here to conduct an EI, to conduct and do an EIS. Is that a little bit beyond what they could do? Because from what I gathered, if it's a type 1, they have to do, there's the presumption there, and then they have to make a determination and so forth, and then ultimately they could end up concluding an EIS does not need to be, an environmental impact statement does not need to be performed. The Supreme Court just went over that and just said, no, I want you now to conduct an EIS. Do you think that's proper to do that?
as a pro se litigant, I can honestly say this is my first foray into the law, and so
Right.
the degree to which it's proper is
Okay.
something that I cannot
All
say
right.
that I have great experience in. In this case, though, I actually do think it's proper. I think that the Supreme Court looked and noted that that the SCA was incorrect in designating it an unlisted property and called it a type 1.
I think the city, I don't think the respondents have argued, at least from what I have in my notes here, that, okay, there may have been a misclassification as type 1, and as my colleague pointed out, the type 1 has a presumption of an adverse, there's going to be adverse impact, right? So that you're going to have to do additional testing or additional tests or examinations and review, so that they'll then decide whether or not an EIS after that situation is even required. So so we're at that point where it's type 1. Okay, you have an adverse effect presumption, but the question for me is, the Supreme Court overstepped its bounds by telling the respondents, you got to do an EIS now, without giving the opportunity for them to go through the whole, machination of saying, well, no, I don't think so.
Well, I was paying attention to opposing counsel's comments, and I was struck by one of your honors mentioning this idea of a hard look. What is a hard look?
Well, yeah, so that's my question. So do you take issue with any of the findings by respondents?
Yes.
And what is the issue that you have, and what is that based upon?
Yes, I do take issue. There were several things, in particular relating to traffic, where we would suggest that SCA did not take a hard look. And it's some of the things that your honors have actually already mentioned. For example, they collected traffic data for a week in April of 2022, which included a school holiday. You're trying to determine the impact of a school. Why are you looking during a school holiday? And then they actually acknowledge in their EAF that this may not represent a typical weekday condition because of COVID. And to augment that, they went and got data from June 2019, which A, does not account for traffic increases since COVID, and B, also does not necessarily reflect a typical school day.
So when is it that you believe that they should look? What dates should they look there for?
Well, one of the things we would like them to do is come back and look, because traffic has, if anything, and I should say I live in the area, traffic, if anything, has increased since we have returned, quote unquote, to normal since COVID. So I think they need to take a look during a week when school is in session for an entire week and see how that affects things. I would also note that opposing counsel mentioned intersections. The street that the school is supposed to be built on is a busy thoroughfare between Broadway and the Major Deegan Expressway. They did not take into account the two exchanges for the Major Deegan Expressway in their analysis. As somebody who has sat in traffic trying to get onto the Major Deegan or trying to get off of the Major Deegan, I can tell you that I have sat there for 10 minutes at a time. I can walk that distance in 4. So they did not take two expressway interchanges, which are down the street, into account. That is not a hard look, Your Honors. They also failed to adequately consider the effects of Tishman Spire's adjacent 334-unit residential development, which has been in a public-private partnership with the SCA. Right? In fact, there's a land use agreement between SCA and Tishman Spire which permits transfer of development and use rights between them. SCA's EAF is internally inconsistent in the way it handles this development, factoring in its impact when it's convenient and dismissing it as a separate action by others when it is not. But since there is no question that a 270,000 square foot residential development combined with a 103,000 square foot school will have a significant environmental impact, SCA's failure to consider this violates a rule of reason and is the very definition of arbitrary and capricious, which is what the Supreme Court called it. I would also like to say, to address opposing counsel in their first comment, which is that since SCA misidentified the project as unlisted when it should have been a type 1, we cannot know how the analysis would have been different if it had been categorized correctly.
Well, yeah, we do, because we know that although they misclassified it, they still, the analysis was for the correct classification.
Well, the Supreme Court found that there is a question
meaning
about
that
this.
there was nothing more that would have been done had they classified it correctly.
With respect, I would suggest that we don't necessarily know that, and that SCA's statement that it would be the same is self-serving, since there is no way to know if it would have been different had their determination been different.
Thank you. So if you could respond to the arguments as to when you took a look at the traffic, and also it is correct in terms of the Deegan. There's an exit off the Deegan at that one of those intersections. You could address that.
Yes, Your Honor. So, I mean, my recollection is that the study addressed that intersection and determined there was not going to be a major effect on it. I think that the most important point, Your Honor, is to note that, because they mentioned the Major Deegan, but they have the discretion to determine which intersections are particularly important to look at, Your Honors, and under the secret technical manual, and that's what they did. I think that, you know, the question here is not whether everything was done exactly the way that the petitioners would do it. The question here is...
The way I look at it is that, from what I'm gathering, is that the petition is asking us to if we were to disagree with you with your findings here, that's almost as a substituting our judgment for your judgment in this case, right? Because we don't have, at least for my purposes, I don't have the benefit of any experts or any other countervailing evidence that would show that what you did was clearly arbitrary and capricious, right? I mean, I only have one set of facts in front of me, as well as the record, and that was all what you guys did, what the respondents did in terms of preparing the EAF or whatever it was, or EAS, right? I don't have anything other to measure than the fact that petitioners are saying that they disagree with all your findings.
I think, yes, I agree with you, Your Honor. I think that, and I would add to that by saying not only is it they do not have an expert, which maybe it's unreasonable to ask pro se's to get an expert, but they don't even have any quantifiable analysis. I mean, they're not giving us any data. They're not giving us any, they're talking about the Major Deegan Expressway. well, what is their data that's going to be a problem? I mean,
Well, I was thinking about that also because I was also wondering, you have a neighborhood school. I was wondering how many individuals are going to be coming to the school via the Deegan? How many are going to be driving? How many are going to be walking? So then my question becomes, all of the data, all of the information that you received, then you compile it into a report that talks about the various factors, and you weigh those factors.
right, Your Honor. And I think that intuitively it seems likely that there wouldn't be too many people, since it's a neighborhood school, coming on the major Deegan, which I think that they do mention it, but they don't go into it much, and that might be why. Let me just say, on the school in session issue, on the April 2022 issue, I may have been off by a year, I said April 2021. But, I mean, I don't know what Ms. Carlson would have us do. We couldn't go into the future in April 2022 and evaluate it now when there's no COVID, when the COVID effects are less minimal. We were doing the analysis back then.
Yeah, I don't even know whether you could go to whether there would be a comparable school or comparable location to try to figure out what the traffic patterns, et cetera, would be. I mean, I think the bottom line is that it's very difficult. It's difficult to make that assessment because you do not know what's going to occur in the future. But so for our purposes, it's whether the determination that was made was arbitrary and capricious.
Right, or whether instead it had a rational basis, Your Honor. That's
Yeah,
right.
so thank you both.
Thank you, Your Honor.
Willinsky versus Burkowitz.
Good afternoon, Your Honors. May it please the Court. My name is Carly Krasner-Laserson, and I represent the defendant appellant Eric Burkowitz. Your Honors, we are aware of the oft-stated general rule that the remedy for perceived inequities in a pendente lite decision is a speedy trial. But in this case, the issues are not perceived inequities. The lower court committed legal and factual errors that cannot actually be remedied by a speedy trial, even if there was such a thing in New York County in this day and age. The lower court erred in 5 significant ways. First, 22 New York Court Rule 202.16, subsection K2, requires a litigant to attach a statement of net worth to an application for child support and/or counsel fees.
Didn't your client attach net worth in his papers, or did I miss something?
My client did. However, the respondent did not, and the statute specifically says that no motion for child support or counsel fees shall be heard unless the application, the moving papers, contain a statement of net worth. Respondent never filed her statement of net worth. The word shall...
But it isn't that the court didn't have an opportunity to review a net worth statement. It's just that the respondent didn't attach one.
Well, so that's actually of no moment because the Second Department in Deitch versus Deitch, which was actually relied upon and cited by this court in Perrone versus Perrone 2 months ago on February 15th, stated that even where a litigant had previously filed a statement of net worth with the court, the application for fees was defective because the statement of net worth was not attached to the papers. And so if even filing it previously is not enough, never filing it at all certainly should not be. The proper course of
It's
action...
akin to the CPR provision saying if you're moving for relief, you have to attach the pleadings, right? And if sometimes we get cases, and I remember in the trial court where the movement forgets to attach the pleadings, but then the other side puts the pleadings in and you're good to go, even though the CPR says you must attach the pleadings to your moving papers. It's akin to that. It's analogous to that kind of situation, right? Are we elevating form over substance here?
I don't think so, Judge, because...
But as my colleague stated, your client did in fact attach a statement of net worth. That statement included the wife's net worth.
Well, no, actually, my client attached his statement of net worth.
But didn't it include the wife's net worth as well?
No, he included her statement of net worth. However,
Right,
this
okay,
that's what-
I thought that's what I just
that's-
said.
okay,
Okay,
okay.
whatever, so, but the point is, the
Had
court
both.
therefore was in possession of both.
except the wife's statement of net worth at the time that this case was actually heard was, by her own concession, stale. With respect to the expense section, she had listed on her statement of net worth that she was paying 100% of the carrying costs for the marital residence, which she was not. And in her reply papers, she actually contradicts her own expenses that were in the statement of net worth that appellant had annexed. Furthermore, the statement of net worth that appellant annexed of respondent had the full amount of a marital account in plaintiff's sole name.
Didn't the court make adjustments in terms of the Pendente Laite award based on what you just said? I mean, in terms of the wife's net worth statements was stale. She said that she paid all the carrying costs, but that wasn't accurate. The court had, at least my record, at least my notes tell me, had updated information so that in terms of issuing the award, adjusted accordingly, right? It wasn't that the court just based the award on all stale information. There was other information presented to the court at the time. Am I incorrect for saying?
I don't recall that, Your Honor, but also even if the court had the requisite financial circumstances of the parties, which they say in rendering the counsel fee award, the court did not adhere to the requirements of this Child Support Standards Act, even though they acknowledged and followed
Your
it.
client submitted the wife's statement of net worth. You're saying it was stale, but your client relied on it.
Well, so no, my client attached it on October 7th. Her statement of net worth was dated in August. When this application was heard and when the respondent submitted her reply papers, that was in January, and that was about 5 months later. And by that point, she claims that an account in her name had been exhausted, but she never provided any evidence of that.
Counsel, let's talk about the $2,000 to be used off of the Amex card. Was there papers that your client put in requesting that a cap be placed on the amount to be used from the credit card for personal expenses?
Correct. When my client filed his application, it was because the respondent had stopped contributing to any of the familial expenses. The parties were still living together. And so as a gesture of goodwill and to show good faith, my client said, while we're still living in the same apartment, she can use up to $2,000 a month on my American Express card for household items and groceries and expenses related to the children. And then in his reply, he says, if this court is going to award child support, the wife should also not be entitled to charge $2,000 a month on my American Express card. The lower court not only awarded child support while the parties were still both residing in the marital residence, despite any showing that the children's needs weren't being met, but then also awarded the $2,000 a month, which created a situation where the lower court specifically found that an $800,000 cap on child support was too high. But then they never did the calculation. Had they done so, they would have seen that the child support number that they actually awarded as direct child support was not only an $800,000 cap, but the addition of the Amex card actually created a situation where the cap was approximately $950,000.
Thank you.
Good afternoon, Your Honors. My name is Susan Bender. We represent, from Bender and Crane, we represent the respondent. May it please the court. First issue I'd like to address is the issue of child support. My colleague makes an argument that the court below erred in not abiding by the child support guidelines, but according to two decisions of this court, the Rubin versus Della Sala, I believe that's how you say it, the courts considering applications for pendente lite child support may, in its discretion, apply the CSA standards and guidelines, but they are not required to do so. My colleague concedes that point. She concedes that point on the very last page of her reply.
Well, I think the issue is that they were still living together between October 2022 and March 2023. And so, but you're awarding child support while they're still in the marital home, they're still living together. And also, we have this American Express limit of $2,000 a month.
Okay, so first, that's true, Your Honor. There was, however, the parties entered into a stipulation in October, and that stipulation went through January 9, and that stipulation provided that my client was to pay 1/3 of the costs of the marital residence, by the way, which is $34,000 a month. That lasted until January 9, and then in March 15, my client moved out. So what are we talking about? We're talking about 2 months, perhaps, for $20,000 on parties who make $1.6 million. The remedy here is a speedy trial, which is what Judge O'Neill Levy said in her decision, that any conflict with regard to those 2 months, if there's a double shelter argument, should be addressed because it's a speedy trial. The second issue on the statement of net worth, this is exalting form over substance, and this was my decision to make. My colleague put in her voluminous papers, not only tax returns and W-2s and 1099s, substantial financial information, she also put in my client's statement of net worth, Exhibit J, to their motion. I said to myself, why do this twice? So that was my decision. I didn't think it was relevant. I think the court had all the financial information, substantial amount of financial information on both sets of papers. So that was my decision. That I did not think it needed to be included. And we also discussed that issue with Judge Kelly O'Neill Levy in Chambers, which is not in the record.
I guess the argument is also that although they did put that information in, by that time perhaps it was stale?
Oh, by the time the motion was finally and fully submitted, months after it was started, it was stale with everybody. For example, we had no idea. Her client, I'm sorry, I didn't say her client. My colleague's client did not put in all his imputed income from his businesses. He did not put in the money he's actually receiving from the trust. He did not put in the trusts. He did not put in any information with regard to that.
I
in these
thought the
papers.
trust monies were suspended. He wasn't getting them at the time.
That's what they said, but they haven't proved it. And we still haven't gone to trial. And those trusts, we had to hire attorneys in 3 states, California, Delaware, and Connecticut, to trace down the trust and these trust monies, because my colleague would not provide the discovery information that we needed in order to ascertain what those trusts really could provide to the appellant. I don't know if the red light is on, or is that the green light? Okay, so on the third issue is the counsel fees. And counsel fees, it's a rebuttable presumption that the moneyed spouse advances the counsel fees. We asked for $500. The court in its discretion gave $150. If I didn't like that decision, the answer would be, for me, speedy trial. We did not file an appeal from that decision, and it's clear that my colleague's client is the moneyed spouse. By his own admission, he has $22 million plus in separate assets, and from those separate assets, he's paying his attorneys, which, by the way, I just want to state the obvious, and the obvious has been this appeal costs more, and the record costs more than probably 2 years of child support at $10,000 a month. Item number 4 is, I believe Your Honor asked about the American Express. My colleague is the one who asked for the American Express, that he provide an American Express. It wasn't contingent in any papers upon them living together and his gesture is good faith. This is a man who makes north of $1 million a year, has $22 million in trust, owns his own medical practice, is paying $34,000 a month for his apartment, and he's whining over a couple $1,000s a month. I mean, this is not that case. And finally, Your Honors, in terms of the double shelter, I believe I addressed that when I talked about the child support. And just finally, I want to reiterate the law of this jurisdiction, Appellate Division, First Department. You don't like a pendente lite decision? Speedy trial. Thank you, Your Honors.
With respect to this speedy trial, the issue regarding the child support is that the Court of Appeals in Johnson versus Chapin and Justice McGuire in his dissent in Anonymous versus Anonymous recognized that you cannot claw back an overpayment of child support. So the remedy of a speedy trial in that regard is actually no remedy at all. Also, Judge O'Neill Levy used the CSSA. She did not choose to not use it. She cited the CSSA. She specifically claims that the guideline amount would be unjust and inappropriate, but she never actually says what that is. She never performs the 3-step methodology that the CSSA requires or that the Court of Appeals in Holterman versus Holterman says is required. And therefore, by virtue of the fact that she wholly ignores the calculations, but then says she's using it, she says, I'm awarding an $800,000 cap is too high, but then orders support on an $800,000 cap demonstrates the errors of her ways, and had she done the calculation, she would have seen that. With respect to counsel fees,
So can there not be any recoupment in the future?
no. Johnson versus Chapman says that you cannot claw back child support, and that would be the issue of why a speedy trial shouldn't be, is not the remedy. Additionally, the appellate division in Ritter versus Ritter, it was with respect to temporary maintenance, but found that where the award was more than to meet the actual needs, you shouldn't have to continue paying it until trial. With respect to the counsel fee award, the decision is silent that it was subject to reallocation. And because of that, it is unclear whether it is. And therefore, that too cannot be remedied by a speedy trial. I also want to note that all of the rhetoric from respondents' counsel regarding trust and all of that is completely dehors the record. None of that is in the record, and there were many statements in their papers that were completely dehors the record. The fact remains that my client submitted an affidavit from Renee Davis. That affidavit specifically stated that the trust distributions had stopped prior to the commencement of this case. That was wholly undisputed by respondent. We also claimed, again, wholly undisputed by respondent, that plaintiff appellant's trust assets are illiquid and he cannot access them. That was completely undisputed. Respondent is not the person that DRL 237A is designed to protect. She makes over $600,000 a year, was denied spousal support because the court found that she had a sufficiently high income to be self-supporting, and she claims that she has more than $2 million of separate property liquid assets in her sole name. The presumption was rebutted, and she should not be entitled to counsel fees.
Thank you. Thank you both. Ravitch versus the City of New York.
Good afternoon, Your Honors. May it please the Court, Susan Paulson on behalf of the appellant city. Your Honors, Supreme Court erred in denying the city's motion for summary judgment. In this roadway defect case, it's undisputed that the city did not have prior written notice of the alleged defect. Instead, plaintiff's theory of negligence is that the city caused or created the alleged defect, but plaintiff failed to raise a triable issue as to the city's affirmative negligence.
Their burden, right, when it comes
Correct,
to that
Your Honor. It is their burden.
Immediate defect, right?
Correct, that the city caused or created.
But here's the question I have is, you have an immediate defect. Let's just say, assuming that there's an immediate defect, it's a ticking time bomb. I mean, it can happen. I mean, where's the timeline in terms of an injury as a result of the immediate defect? Does it has to be right away? Can it be 6 months later? Can it be 4 months later? I mean, do you follow that?
I mean, there has to be evidence that the city's repair work immediately resulted in a defect.
But the issue is what constitutes immediate. So the incident occurred on January 13, 2016. The repair of the potholes were made to 2015. So
Correct.
we're talking about approximately eight months or so
correct.
prior to.
Correct. That is far outside any timeline that the courts have ever recognized as immediately.
But when you look at the photographs, I mean, you see, we almost have a sinkhole now. I mean, it's just very interesting in terms of how did the pavement, how did the street, right? How did it get to that condition?
Your Honor, first of all, it's unclear that the photographs actually represent the defect that the plaintiff alleges caused the fall. The plaintiff explicitly testified that he tripped in the easternmost southbound lane of Broadway. There are two southbound lanes. He stepped off the median, he took 4 or 5 steps, and in the lane closest to the median, he tripped. The repair record explicitly states that the repair was in the middle of the southbound lanes.
In the middle of Broadway going south.
Right. So there are 2 southbound lanes. He was on the easternmost portion of one of the 2 southbound lanes. And the photographs don't show that the defect was there. But regardless of whether or not the photos show a defect in the location, there's simply no evidence in the record that the city's repair 8 months prior to when the plaintiff fell immediately resulted in a hazard.
So
I think the record evidence, I'm sorry, Your Honor.
But I think this goes back to the original point of, I think Judge Weber made it. How do we define immediate or immediately?
Yes, immediate has to be right away. There's no case law that says within
Okay, how do we
24
define-
hours or 36 hours.
How do we find right away?
But there's,
What's right away?
yes, Your Honor, there's certainly cases that say months later is not right away. There, and
You're not going to know, but that, maybe I'm missing something, but you're not going to know about right away until until an injury happens, right? I mean,
No, Your Honor, I mean, there could be complaint records, and in this case, it's undisputed that there were no complaints about a defect in that area. And not only,
Perhaps no complaints because no one fell, there wasn't an accident.
that's what I'm trying to.
sometimes there are no complaints because there are no accidents. But in addition to that, there was a plaintiff's own testimony that it was 2 blocks from his home. He walked there daily, and he never saw the defect. So we have a repair record that says that the repair was closed and repaired 8 months prior. We have no evidence of any subsequent complaints or subsequent repairs to that area. And we have the plaintiff's own testimony that this was 2 blocks from his home. He walked there daily, and he had never observed it previously. So, Your Honor, simply it's the plaintiff's burden, as we started, to establish a triable issue. And all of the record evidence established that there was no defect immediately apparent following the repair 8 months prior. And you can't raise a triable issue simply by speculation, which is what the plaintiff tries to do.
But we have the broken asphalt, right? We have what appears to now be a sinkhole. So, and then we have that it was repaired. Why don't we at least have enough to establish an issue, a fact that should be pursued?
Because the photographs are 8 months, there's no connection between what you're describing as a sinkhole and the city's repair 8 months prior.
Well, how do we know that at this point in time? Why could we not, I don't know, is there would there be an affidavit by an expert saying that, this looks to be something that was teetering, that was about to occur, an accident, in terms of the repair, something that, 8 months, this is what happens if it is improperly repaired?
Well, certainly that would be the plaintiff who would have to introduce such an affidavit.
Yes.
And they introduced an expert affidavit here that stated only legal conclusions, which Supreme Court properly rejected. And plaintiff does not argue on appeal that the court erred in rejecting that affidavit. That expert posited that an insufficient amount of asphalt was installed, and
But once that
perhaps
affidavit is rejected, the plaintiff only has the photos.
that and the repair record saying it
his
was
testimony.
closed, and the plaintiff's own
His testimony works against him, doesn't
Right.
it?
his testimony works against him, as does the closed repair record, as does the absence of any complaints or the absence of any complaints. So there simply
Even if
is
I
no.
did, even if my concern is that where is the? I mean, it's a ticking time bomb. It can be triggered. I mean, you're not going to the immediacy. You're not going to know until an accident happens. In this case, plaintiff's burden, it really doesn't really even to respond to me to create even a factual issue because it's not there.
Correct. And the plaintiff simply came forward with no evidence. The plaintiff points this court to a 2010 Supreme Court case in which there was testimony from a DOT repair worker and supervisor about the steps that were taken on the repair and about the condition of the repair immediately afterwards. We have no testimony like that in this case.
I'm sorry, what is the strongest precedent you have that would direct the outcome you're asking us to arrive at?
Well, honestly, Your Honor, the strongest precedent is probably Bilecki that requires an immediate defect. But in addition to the Bilecki case requiring the immediate defect, I would point this court's attention to, pardon me for 1 minute, to the cases cited in our reply on page 10, the Civic versus City of New York and Hammond and Cardona, rejecting a speculative claim that a defect several months before the accident immediately caused a hazardous condition. So I would point the court's attention to those precedents. And I will reserve for rebuttal. Thank you.
Thank you.
Good afternoon. Dominic Rendina on behalf of Joseph Rabich, Linda Rabich on behalf of Joseph Rabich, who is now deceased.
So we don't have notice, which we recognize as no notice.
That's
right?
correct. We can
Okay.
say that there is no prior written notice.
Okay, so now we move on to the issue as to the negligent repair, I guess.
Right.
So if we don't have the expert affidavit, then all we have are the photographs?
Well, I think we have more, and I'd like to explain. First, if I may, I'd just like to address the subject of plaintiff's testimony. Mr. Ravitch is an 86-year-old man at the time when this accident happened. This accident happened at 9:30 at night. So he may have traversed that roadway in the past, but, we're not talking about sunny Saturday afternoon where he can see what's around him. I'm sure his vision is already impaired at his age.
Are we making assumptions now? I mean, he was rather clear in what he said. He lives by there. He walks there all the time. He didn't see the pothole, so why can't we take him on what he said?
I think we could take it on face value, but I also think that maybe he didn't see the pothole because of those factors, and I think that's maybe not necessarily a
Well,
assumption.
that's not really the issue, because the issue is not so much it was 9 o'clock at night or whatever time it was, and therefore he didn't see the pothole that he stepped in that evening. It's that his testimony was that he had traversed that area almost on a daily basis and never saw any pothole. So that's the portion of his testimony that, becomes an issue, at least for you.
Okay.
He said in the past he never saw the pothole. He didn't say, and also there was nothing in the record that he always traversed it at 9 o'clock at night. I'm assuming, I do not know, but I think for the sake of argument, you can assume that he traversed that area at times when it was daylight, and he says he never saw the pothole.
Okay, fair enough, but I think the accident happened at 9:30 at night. That's when he didn't see the pothole. That's when he fell in the pothole.
That would be helpful if it was the city's burden to affirmatively show that they didn't create the defect.
Right.
Under Yarborough, it's your burden, as I read Yarborough, it's your burden upon the showing of lack of prior written notice to now raise a triable issue of fact as to an exception. So pointing to an ambiguity or potential fallibility of the witness's memory, I don't know that that's going to get you where you need to go on now, what is, I think we all agree, your burden.
Oh, correct, and that was just my first step. I'd like to move forward on the next point. You were asking earlier, counsel, what is the definition of immediate resulted? Now, I think that I point to the 2010 UT case. In that case, it's almost identical to our case. We have a fall in a pothole in a walkway, and we have a plaintiff's affidavit from their expert engineer that cuts against them, just like ours does, because ours was supportive, but the court dismissed our affidavit as conclusory. But we have almost identical situation here. In UTC, the supervisor for the DOT work crew testified exactly what needs to get done to repair a pothole. And I think this will define for us what exactly, this is the handbook for a DOT road crew. This will define to us exactly what kind of condition will result if a repair is done improperly. And what happened here is, if you look at the case and in my brief, the repair was done so quickly and so hastily that they spent maybe 2 to 3 minutes on each pothole. And the supervisor even testified that you needed to spend a good 20 minutes for the compound that goes into the hole.
Have you ever seen the pothole brigade on the streets when they're filling
All the time. We see them all.
Have you ever seen them spend 20 minutes on a pothole?
Well, I'm just talking about what the proper
I
procedure
haven't really
is.
timed them, but, I would be very upset if I'm behind the pothole brigade and they're taking 20 minutes to fill a pothole.
I would agree.
It's normally, I think, about 2-3 minutes that they take to fill a pothole that I've seen.
Well, I'm just talking about what is proper in order for a pothole not to be
But
remade.
again, we're back to the same issues in terms of what's immediate, what is not immediate, whether or not you can hold the city to any level of negligence based upon the filling of the pothole.
Well, to that I say the pothole should have been properly filled.
But sir, I'm sorry, but doesn't that go to their negligence? Not whether a condition immediately was created thereby. They could be abjectly negligent, but that doesn't necessarily mean the defect will immediately appear. And so again, what is, is it like, it's got like a Potter Stewart quality. We got to know it when we see it. What is immediate?
Or are you asking us to speculate that because it took such little time to fill the pothole that this defect must have immediately occurred?
Yeah, I can see if they filled the pothole 2 minutes and then your client steps off and he steps into the pothole. Then he steps into what should no longer be a pothole. Then I can understand it. But I think we're back to the issue of immediacy.
Well, I don't think there was a hole per se. I think there was a depression. I think that's what our expert was saying, is that the hole wasn't properly filled. And I think that goes back to the supervisor's testimony in UT where he says, if it's not done properly, an immediate defect will result. And yes, to answer your question, Your Honor, the whole, we're not just speculating here. If you take the math in both gang sheets and you take the time spent in both gang sheets, and the resulting UTC was a defective condition, I think it's not too far of a leap to say that we have a defective condition resulting in ravage. I don't have an affidavit from my expert, is what I would need to support me fully. Yes, I concede that. But in UTC, the court discounted or dismissed the engineer's report, and he looked at the supervisor's testimony. And I think looking at that and just doing the math and looking at both gang sheets, you see they're almost identical. And if you have identical work being done in the identical fashion in the identical amount of time, I think you're going to get the identical results here.
Sir, is there any prohibition on us considering factual material from another case for the purpose of establishing a burden? I mean, we could certainly take judicial notice that someone gave testimony in a case, but as far as what a practice was, what a conclusion was, are we allowed to take judicial notice of facts from a different case for that purpose?
I do not know that, Your Honor.
Thank you.
Thank you.
Very briefly, Your Honors, this court may not adopt factual information outside the record. And I would also point out that not only is this factual information outside the record, but there's simply no evidence in the record that the same materials or the same techniques are used today that were used 15 years ago to repair a pothole. And not only do we not know that the same materials are required or the same techniques are used, we have no information about the size of that pothole versus the size of this pothole or what was required to repair them. There's simply no reason to take the testimony of a DOT supervisor from a pothole 15 years prior that we have no information about. In addition to the fact that there's no information about the materials required or the techniques used, there also was information on a case that 2 essential steps were skipped in repairing that pothole. There's no such information here. We have no idea what steps were required or if any of them were skipped. And then finally, there was information in that case that at the conclusion, there was a gap around the perimeter. The DOT supervisor said there was a tripping hazard. Certainly, that's a defect that immediately resulted from the repair. And that's the type of immediate result that this court has recognized.
Viewing the evidence in light most favorable to your friend as we must.
Yes.
And understanding that where there's any doubt, summary judgment should be denied. Should we err on the side of caution in light of the nature of the defect that's depicted in those photographs?
No, Your Honor. To the extent that we view the evidence in the light most favorable to the defect, I would say there could be a tribal issue of fact as to whether or not the defect in the photographs was at the location of the fall. I think the record is arguably a little muddy on the fact on that issue, but I don't think there's anything here. There's just simply no evidence in the record to create a tribal issue that the repair 8 months prior immediately resulted in the defect. The photographs are not sufficient to do that. All of the evidence in the record was to the contrary. The testimony of the plaintiff, the repair record itself, the absence of complaints. And so Supreme Court erred in denying the city's motion for summary judgment.
Thank you.
Thank you very
both.
much, Your Honor.
Agard versus the Port Authority of New York and New Jersey.
Good afternoon, Your Honors. May it please the court. Jack Watkins for the appellant Island Diversified. I have to admit I'm a little nonplussed by the fact that structure tone isn't here, but I'd like to nevertheless address the aspect of our appeal that addresses the grant of summary judgment to structure tone and the Port Authority on the conditional indemnity.
So you represent Island?
Yes, that's correct, Your Honor. So Island was essentially aggrieved by 2 portions of the summary judgment decision. Sorry.
We're listening. We can multitask.
Island was essentially...
Well, at least the women can multitask.
Oh, ouch.
Ouch.
Island
I'm
was
not gonna
essentially.
We
disagree.
get along really well on this bench.
No, I'm not gonna disagree. I won't disagree.
Island was essentially aggrieved by two portions of the summary judgment orders that were issued. One granting summary judgment to what I call structure tone in my papers, but really that cluster of parties, the owner and the general contractor and the lessor, on their conditional indemnity claim. The jurisprudence of this court and the trial courts within it supports the granting of conditional summary judgment on contractual indemnity in an appropriate case. And while our papers do invite you to join the second department's jurisprudence on that issue, as of course they do, you don't need to do that in order to reach the issue of reversal here. The burden that a movant for seeking that kind of conditional contractual indemnity has is to eliminate all issues of fact as to whether they were the 100% negligent or solely actively negligent party in the case. Structure tone did not do that. And interestingly enough, the court below didn't even hold that they did. The court reached its decision to grant summary judgment on the grounds that the plaintiff had withdrawn their Labor Law 200 claim and expressly reasoned on the record that because there was no negligence claim brought against the general contractor anymore, that meant as a matter of law, the general contractor could not have been negligent. And that's just a non sequitur. In order to establish that your entitlement to contractual indemnity, you have to establish that you're to some degree free from negligence because of the GOL. And it's of course possible that a fact finder could conclude that they were the only negligent party. And Justice Higgett, your comment on the prior appeal was very well taken in that regard. The standard here is the light most favorable review. If there's any possibility.
What's Ireland's relationship to the scaffolding itself?
Oh, it's our scaffold for sure.
It's your scaffolding.
Yes, we can't run from that.
Okay.
And the scaffold did fall, but it fell when the wheel on the scaffold was placed over a concealed
Oh, no,
trap-like
not,
condition.
the plaintiff testified that he wasn't sure in terms of the sequence of events whether or not the wheel fell off the scaffold and then it fell through the hole.
No, that's true, but either way, it punched through the.
Well, but if the wheel fell off the scaffolding prior to its punching through, then would there not be some liability on the part of Ireland as it's your scaffold?
Yes, 100%, Your Honor, but that would be an issue of fact. If there's an ambiguity, deciding as a matter of law that that must have happened and therefore structure tone can't have been the only liable party doesn't make any sense. The trap or pit-like condition is covered by masonite. Masonite is a type of hard cardboard. It's actually this. They use it to make the back of clipboards.
Structure tone's liability here is not vicarious, it's direct because it was involved in doing a lot of work on the premises, correct?
Well, yes,
So
that's
conditional. This conditional finding of this award of a conditional indemnity, you still have to be a determination of who was to blame, either structure tone or you, right?
that is our position, Your Honor. So plaintiff.
Why shouldn't there be a conditional a conditional liability at this, but it's conditional summary judgment, right? It's not, you can get a slam dunk. You don't have to provide indemnity to them.
You're right, Judge. Let me distinguish between.
Right, but I'm just pointing out something that I'm looking at.
Let me distinguish between a couple of different things. And I'm sorry that this might be a little bit pedantic, which is one of my vices. Plaintiff prevailed on a labor law 240,
Right.
which is strict liability.
240 and 241, I think, right?
240 and 241. So that's strict liability and vicarious liability, respectively. That's why plaintiff withdrew the labor law 200. They
Yeah,
didn't
but the
need it.
wrinkle here is that structure tone, I would agree with you, but the wrinkle here is structure tone had a big involvement in this project. It wasn't just standing by and merely, being held liable for vicarious liability.
Precisely, you're agreeing with me. So that's the basis on which the summary judgment was decided. However, when the labor law 200 claim was withdrawn by plaintiff as moot, that in no way indicates the structure tone was not actively negligent. I will actually refer to.
But there's no finding, right?
There's no finding one way or the other.
gone, right?
Correct. But in effect, there was, because Justice Hagler's reasoning on the record in finding conditional indemnity against my client, said, okay, they might be up to 99% negligent, but they can never be 100% negligent because there's no active claim against them. Again, that's a non sequitur. They could absolutely still be, they're going to be on the verdict sheet, and to your point, there's going to be an allocation of fault between at least us and at least them. And why
You have
shouldn't
time
the
on
jury?
rebuttal. Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court, Irina Kravchenko. I represent third-party defendant, respondent, Consolidated Carpet in connection with this appeal. It is Consolidated Carpet's position that the Supreme Court correctly dismissed all third-party claims against
You can't leave that site until you get the green light from Structure Tone, right? Is that correct?
Absolutely, Your Honor, yes.
This is a friendly question.
Yes,
It's not
yes.
just, you don't have to think
For
through
a
it.
second, I was like, does that pertain? Yes,
Right,
absolutely,
so,
Your
I
Honor.
mean, and you were gone already when this happened. I think, I forget how many days out you were.
3 weeks, Your Honor, yes.
You were 3 weeks out of that floor, right?
Yes, absolutely. Absolutely, Your Honor, that is exactly Consolidated Carpet's position, entirely based on the testimony from Structured Tone, that he inspected repeatedly, approved, released, allowed the other parties to come in, and that he never saw an open hole. And therefore did not arise from Consolidated Carpet's negligence or from its act of not replacing the cover. Unless the bench has any questions, I'll rest on my brief.
Nope, thank you.
Your Honors.
Good afternoon, Your Honors. May it please the court, my name is Karen Ondrovic, and I represent the respondent, High Tech Data
Same
Floor.
with you.
Same thing,
Same
right?
thing with you, right?
Yes, Your Honors, our position
You
is
got the 3
exactly
weeks
the
go,
same.
goodbye.
And I don't want to take the court's time if you don't have any
Oh,
questions.
I'm just saying that, yeah, I mean.
It's
Yeah,
Same
we,
thing.
we were even further removed because we were there 6 weeks earlier, and in fact, we were on the 70th floors where we completed our work. The 65th floor is where this happened. So we had gone to the 70th floor. We had actually submitted our final requisition papers on November 1st. This accident happened 6 weeks after we completed fully our work at the project.
Right, and nothing could occur until you tendered the site.
Correct. There was absolutely no dispute
You
by
got to dot your I's
Structured
and cross
Tone.
your T's. I seen some labor law cases that facts are all over the place, and this one was like, well, this is pretty good.
Yes, well, I must say, Structured Tone had a pretty good project superintendent who was quite adamant that he inspected every floor. In fact, his testimony was, I was there in December 2018, so a month after we were gone and before the plaintiff's accident, he said, I know the covers were all there. In fact, he said
Structured Tone helped you.
they did help us, and so for that reason, we feel that the lower court was certainly right and correct, and that the decision should be affirmed, that there is no finding of indemnity.
Thank you.
Thank you, Your Honors.
They didn't really help you, though.
Well, thank you, exactly.
And not showing up really
And not
makes
showing up.
makes it even harder.
I don't know if the bench would like to be heard by me on the issues raised by Consolidated and High Tech, as they both argued that you shouldn't listen to me on that issue. And in my reply papers, I've cleverly said, well, that doesn't matter because Structure Tone's here and you can hear it from them. Oops. But nevertheless, it's before you in their papers. So if I can briefly say, everything you've just heard is 1,000% correct if this is a negligence trigger. And I don't think it is a negligence trigger. I think it's an arising out of trigger in the indemnity clauses. But what I know, whether it's a negligence trigger or an indemnity trigger or an arising out of trigger, I know it's the same clause for all three of us.
Yeah.
And I know that Justice Hagler, for some reason, treated it as a negligence trigger for them, letting them out of the case, and treated it as an arising out of trigger for me, and said, if your scaffold fell, then it's arising out of for your guy. Well, that's a catch-22.
But the practical effect of this ruling that Justice Hagler did was that it's a conditional ruling, right? So that if it comes down to if Structured Tone is 99%, that's it. You're not going to have to indemnify them, right?
Well, I would indemnify them for the 1%.
For the 1%.
But I do want to address that, and I think you're right, and I started to say this before, and I went off in a different direction. There's two ways Justice Hagler could have granted conditional indemnity. He could have held this is a binding indemnity clause, and you're going to indemnify them to whatever degree they're not ultimately held to be at fault in the allocation, but I'm reserving that for the finder of fact. The finder of fact is going to assign that number. He could have done that. If he had done that, I don't think I'd be up here on an appeal. He didn't do that. In his actual decision on the record, he said there's no way a jury could find them 100% at fault. So that's the part I think should be reversed. A jury could find them 100% at fault, drawing all inferences.
Well, I don't think his statement precludes that. I mean, you're saying that that statement precludes actually a question going to be presented to the jury. I'm not so sure that that's accurate. I mean, it's still going to be presented to the jury in terms of the breakdown, the apportionment, right?
I agree, but he could certainly...
You're just concerned that it may not, that someone's going to point to that and say, you know, you're out of luck on that one.
Well, it is my concern. He could certainly, or another judge trying the case who feels bound by law of the case, especially if you affirm, could say, yeah, he said on the record, there's no way they can be 100% at fault, and the verdict sheet has to tell the jury,
but you can't reconcile that with the conditional aspect of the award. It's a conditional. It's not, you know, you're going to have to indemnify.
Then I would just ask that whatever decision the court issues, make that distinction clear so that I don't have that problem. Thank you so much.
Thank you. Brown v. Riverside Church. Brown v. Riverside Church.
Good afternoon, Your Honors. My name is Elizabeth Kate, and I represent the plaintiff appellant in this matter. In preparing for this argument, it became clear that the complaint does not support facts sufficient to support a theory of ratification that would permit plaintiff appellant's claim for sexual abuse and battery to go forward. So while we believe that ratification can be an appropriate legal vehicle to proceed on a claim of sexual abuse and battery in a child sexual abuse case, at this time we are no longer challenging the trial court's dismissal of the sexual abuse and battery claim.
Counsel, how do you get around our statements, whether they were holdings or dicta, but there were certainly statements in a few of our prior cases, such as Hurley and Conde, that were to the effect that if you can point to a cognizable traditional tort, you cannot proceed on an IIED theory?
Yeah, Your Honor, we're not arguing that in certain cases, intentional infliction of emotional distress can be dismissed as duplicative if the conduct is encompassed in a traditional tort, as Your Honor pointed out. But what we're saying is that here, in this type of case, in a case that alleges that an institution knowingly permitted one of its agents to continuously abuse children and to abuse, in our case, a 12-year-old child who was a player on a youth basketball team run by the institution, intentional infliction of emotional distress is not duplicative of negligence in those cases because the conduct is not encompassed, right? The intentional conduct is not encompassed by the negligence claims. And that's what distinguishes our case from the cases that Your Honor refers to and that the respondent cites in its brief, because the cases that the respondent cites in its brief all dealt with different torts of defamation, libel, slander, malicious prosecution, harassment. And those cases are red herrings because they don't address the precise issue that's raised in this case, which is whether and when the tort of intentional infliction of emotional distress can be held duplicative of negligence claims.
Well, I mean, I think this word, quite frankly, duplicative is simply wrong. You know, not under a common definition of the word duplicative. They have different elements. So I don't think they're duplicative. I think it really ties to the fact that under substantive law, you're usually steered towards a more traditional cause of action. I think one of my colleagues earlier mentioned to me the example of a party who tries to plead fraud when they're also going under a breach of contract theory. And normally the law forces the plaintiff there into a breach of contract, not because it's quote unquote duplicative. They're not identical. They have very different elements. It's because the substantive law steers you that way. You have contractual remedies. You must look to those, not in tort.
Yes. And Your Honor, Well, two things. First is that the basis of the trial court's dismissal of the intentional infliction claim was, in the trial court's word, that that claim was duplicative of the plaintiff's negligence claims. And so that's what we're claiming is error. And as Your Honor rightly pointed out, it's not duplicative. It has different elements, and plaintiff is proceeding under a different legal theory in trying to proceed with the tort of intentional infliction of emotional
I'm sorry to
distress.
cut you short, but I just see your lights on. Could you marshal for us, assuming that we find that it's not quote-unquote duplicative, or that you're otherwise compelled to seek relief under more quote-unquote traditional remedies, what are the facts that would support this very demanding cause of action for the extreme and outrageous conduct?
Certainly, Your Honor. Well, the facts are that the respondent knew that its agent, Mr. Lorch, was a child molester, and it appointed Mr. Lorch to be the coach of the youth basketball team that respondent organized, founded, and controlled. Despite this knowledge, the respondent did nothing to protect the children that he was coaching, to fire him, to discipline him, to publicize his abuse.
How did respondent know or should have known about any prior child molestation by the employee?
So plaintiff appellant alleges in the complaint that Lorch had abused many children other than the plaintiff, and that one of his teammates who was playing on the team at the same time as Mr. Brown has filed another lawsuit alleging that Mr.
But that was in 2011. That lawsuit was filed in 2011, was it not?
Your Honor, the lawsuit was filed in 2020 pursuant to the Child Victims Act.
No. The other individual. That lawsuit was filed in 2011.
Well, Mr. Lorch was prosecuted for sexually abusing a minor in 2011. There's no evidence in the record on when that abuse occurred. There's also no evidence in the record on when Mr. Dye's abuse occurred, which is the teammate of Mr. Brown.
But this is what you're saying, this is what you're relying on in your complaint, that Riverside knew or should have known.
Yes, Your Honor, and at this stage, Mr. Brown's allegations have to be accepted as true, and he's entitled to pursue discovery on when exactly these other children were abused, was the abuse reported to Riverside Church, and to develop discovery. And the trial court's decision, this is the main point that I wanted to get across today, the trial court's decision is significant because it deprived Mr. Brown of that opportunity to prove that and to develop discovery and to eventually prove that Riverside's conduct was intentional. So his negligence claims remain, and he's certainly entitled to pursue those claims and prove to the jury that Riverside acted negligently, but he's no longer allowed to pursue the theory that Riverside acted intentionally, that it knew, that it had complaints made to it, and that it did nothing and allowed this child molester to continue to coach its youth basketball team.
Thank you. You have time on rebuttal.
Thank you, Your Honors. May it please the court, my name is Philip Pizzuto, attorney for respondents. I guess I'll be quicker since the ratification issue on the second issue regarding this case has now been withdrawn. But I think looking just at the complaint is all we really need to do, and that's whether or not the trial court held in dismissing the intentional infliction of emotional cause of action, the complaint alleged no factual conduct beyond the same set of facts and allegations of misconduct in plaintiff's negligence.
Where else in the law is a plaintiff deprived of the opportunity, which the CPLR expressly allows, to plead alternative theories under the same factual scenario? For instance, in a labor law case, do we tell a labor law plaintiff that you can't pursue a labor law 200 or 241 cause of action because you can look to 240?
No, I mean, but those are different sets of facts.
But the legal principle, why? It's failure to state a cause of action, not failure to state one too many causes of action. So really, doesn't it boil down to whether the plaintiff adequately pleaded extreme and outrageous conduct?
That is precisely what I'm getting to. It's the plaintiff only alleged that the defendant knew or should have known that Lorch had the propensity, the offender, the agent, had the propensity to sexually abuse children. That's not outrageous conduct.
Well, also that the sexual abuse occurred during the basketball practice, that the employee had been accused of sexual misconduct on multiple occasions, that the employee was prosecuted on rape charges and indecent assault and battery in
Right.
2011.
Right,
So
that
these
was-
are all allegations.
These are all allegations that occurred a year before Lorch died in 2011.
But we are now at the pleading stage. This is a 30-11 motion.
You're at the pleading
So
stage.
why not therefore just just proceed with discovery and have the plaintiff obtain information from your client as to exactly what your client knew or what your client did not know, and when they knew or did not know it or did not receive the information.
And that's precisely what's going on now. But when you're drafting a complaint, you have to have a good faith basis to draft allegations in that complaint. The court has narrowed this type of allegation because it is extreme. And as a defendant, you're entitled to defend yourself at first blush. And when this complaint was filed, our client, as many other clients, may want to defend it right at the outset. They could have amended. They could tell you now why this allegation belongs in the complaint, but they can't.
What
because they don't have the
litigation-
factual predicate to do so.
What litigation efficiency is achieved in this case by removing that cause of action?
In terms of damages, nothing.
Okay? How about its terms of discovery?
Discovery is ongoing. They're getting the discovery they want. They could argue to any jury or a court that these were intentional acts. They don't need to get there. They just need negligence. They could use recklessness. But this is a cause of action that has to be pled. It's an intentional cause of action. They could have pled negligent infliction of emotional distress. They chose not to. And they could have amended and alleged those facts. They point to the Second Department cases, but in those cases, the plaintiff said not only did the church in that particular case know that the sexual acts were going on, but then concealed it. There's none of that here. So if there was, I wouldn't be here. Probably not. And they had the opportunity to amend. They can't because they don't have the sufficient facts. And we could sit here. We've been litigating, more of these cases now, and I can tell you that they're not going to have the facts.
So then you have a ripe motion for summary judgment.
I would at that time if this was permissible, but it's not because you have to do it. Giving you just before my time is up, as an example, if a defendant now, an employer, all they need to do is hire a sexual offender who's now incarcerated out of jail and is on the list, but they're now running their restaurant. If the allegations as pled here that the defendant knew or should have known of the propensity of that person to commit an act, then every employer who hires someone who has been rehabilitated and back in society and working is now going to not be able to defend this at first blush because
sir,
they know.
Now again, we know these IIED cases are so fact specific, and I appreciate the analogy you just made, but here, don't we have more in that it was a child, and it was a child working through a youth basketball team attached to a church? There's more of a close relationship. Does that make it more extreme or outrageous than the example I understand?
Well, the act is outrageous, and you don't want my personal opinion on the act, but the defendant is the institution here in the church that didn't know about the act. In fact, in their pleadings, in the factual pleadings, they claim this happened behind closed doors. And four separate acts to this individual plaintiff happened behind closed doors some 50 years ago. No one saw it, not even none of the teammates saw this. So how would the institution now have to defend on this extreme allegation of outrageous conduct? How so? Plead it correctly, and then we can defend it. And it wasn't done in this case, and that's why this court should affirm the decision below. Thank you.
Thank you.
So, counsel, do you have to plead facts alleging concealment to sustain the cause of action?
Your Honor, I would argue that the facts that plaintiff appellant alleged in his complaint, every fair inference that can be drawn from those facts, which plaintiff appellant is entitled to at this stage, does reveal that he is saying that Riverside concealed its knowledge, concealed the child sexual abuse.
So are you saying, yes, you do have to allege facts relating to concealment?
facts from which concealment can be inferred. I don't think you need
What
to use
facts
the word
in the complaint here do you allege we can arise some level of concealment?
Certainly, that Riverside knew that Lorch was a child molester, that he had molested other children on the team, and that they did nothing. They didn't report him to law enforcement. They didn't fire him. They didn't.
So
How does
knowing
that
what-
rise to the level of concealment? And those cases that mention concealment, how it's not the same. I mean, those cases that mention concealment and what you just spoke of, there's a difference there.
Well, Your Honor, I would argue that if you know about something and you don't do anything about it, you don't take steps to prevent that bad act from happening that you know can inflict severe emotional distress on a child, that you're concealing it, right? You don't make
I think, counsel, the better argument is I think you could argue that what you just said amounts to outrageous conduct and extreme conduct. You don't have to even go into concealment. I mean, I'm listening to your argument. I think if you are alleging extreme conduct, outrageous conduct, and you have allegations there, in my mind, you've sufficiently pleaded. I'm gonna say you can't prove it.
Because your
you've pleaded.
complaint,
Yeah,
your complaint never mentions the word concealment. You never allege any concealment, and I'm not sure that what you just stated constitutes concealment.
Your Honor, the Eskridge and Novak case do mention that the plaintiffs in those cases had alleged that the institution concealed the child sexual abuse.
Right, they do, but does that make concealment now a required element?
I don't think that alleging the word concealment, I don't think it's a magic word that somehow permits a claim of.
No, the question is whether or not do you believe, is it your argument that you need to show concealment in order to establish an IIED?
No, Your Honor, I think that.
Well, does concealment not make it intentional? Like, you have to establish the element of intentional, so do you not need to show some concealment to make the action intentional?
Your Honor, I think what we've alleged in this complaint and what we should be entitled to proceed to discovery is that Riverside knew, right? We've alleged that Riverside knew that Lorch was a child molester, okay? And that he molested other children. And we're entitled to develop those allegations by exploring exactly what did Riverside know. Were there complaints made? How many complaints were made? Was it one complaint or was it 50 complaints? And that difference between Riverside acting negligently or recklessly and intentionally, that's an important distinction, and a jury would view those two claims and
I
those
think
two
that
theories differently.
in your complaint you use the terms engaged in, joined in, and conspired. What does that get you with regards to concealment?
I'm sorry, Your Honor, I didn't hear the question.
You use the terms, as far as I could recall, engaged in, joined in, and conspired. What does that get you with regards to concealment, if anywhere?
Your Honor, I think that there's a certain level of knowledge and disregard of the knowledge that makes the conduct rise to the level of intentional concealment. And so that's what I'm getting at here. You don't need to allege the word concealment to have the fair inference from those allegations be that Riverside knew and concealed it. Concealed it by not telling anyone about it, by not telling
the
the
fact
parent.
of concealing, that goes to intent, right? You're not saying that concealment is now a new element that must be pled.
No, Your Honor.
So you're saying that you can allege, as you do in, I believe is 128 or 127, an element of conspiring, which would then make it, put it on the same, I guess, make it establish the intentional portion.
Intentional infliction of, right, the intent to inflict emotional distress, yes, Your Honor.
Well, that's what the intent element goes to, the intent to inflict emotional distress.
Yes. As to the points that my colleague made, I mean, I think Your Honor seized on a good point in that we're not saying that anyone with a criminal history can never be hired for any job, but rather should not be put in a position where they're coaching children. Someone who has a known history of molesting children shouldn't be put in a position to coach children in an unsupervised context, which is what we allege here.
Thank you. Thank you both.
Thank you, Your Honor.
People v. Stephen Pittz.
Good afternoon, Your Honors. May it please the court. My name is Mark Zeno, and I represent Stephen Pittz, the appellant. Mr. Pittz asked for a new lawyer 5 times on 5 separate dates over the course of 7 months. Each of those requests was serious. His requests were met with responses from the court ranging from please be quiet to denied to
Did he ever say why he wanted a new attorney? Those 5 times, did he ever say why?
No, he did not. The first 4 times, he was essentially prevented from making a record by the court's responses. The court essentially denied the request immediately.
Counsel, all those denials, or I guess I should say all of those requests came after some sort of negative ruling from the court, right?
For sure.
Go ahead.
And it was after defense counsel argued strenuously on behalf of your client.
Yes.
And also after the defense attorney asked for a particular plea and the prosecution and or the court said no, that's not an appropriate plea, then the defendant would say, I'm asking for a new counsel.
Yes. None of those are inconsistent with my client's right to ask for a new lawyer. My client was very frustrated with the proceedings. He was frustrated with the crime he was charged with. He was frustrated with the fact that he was sitting in Rikers Island during the pandemic.
So, counsel, so I'm sure every defendant is frustrated at sitting in Rikers Island, right? But the point is, to speak directly, your client wanted a misdemeanor plea. Was not happening. So he wants a new lawyer. So they get him a new lawyer. Once a misdemeanor plea doesn't happen, he gets another lawyer?
He gets an opportunity to explain why he wants another lawyer. And that's all we're asking for here. That's what Sides requires, a minimal inquiry as to why he wants a new lawyer. He asked for a new lawyer 5 times. 4 times, the court denied it out of hand, said, please don't talk, be quiet.
And on that 5th opportunity, what did the defendant explain?
On the 5th opportunity, the court said, my client said, I'd like a new lawyer. The court said, why? My client began to talk about a 30-30 issue, which was not relevant to his request.
He said that the certificate of readiness on the part of the people was illusory.
Correct. And the court immediately said, denied, you're not getting a new lawyer.
And he also, because he stated that the attorney had failed to raise a particular argument. Well, because of the fact that the certificate of readiness was illusory.
My client spoke about the illusoriness of the certificate of readiness. And the court, what the court should have done is said, yes, I understand you're frustrated with the certificate of readiness and the speedy trial time, but why do you want a new lawyer? That's not relevant to that question. The side says you need a minimal inquiry into why the client, the defendant, wants a new lawyer. And that just never happened here. That discussion never took place. Your Honor, you spoke a moment ago about plea negotiations. And that's a very good example of my client's frustration and the breakdown of communications with his lawyer, because at one point during the proceedings, the client said, Mr. Pittz said, I want to take that plea. The court said, speak to your lawyer. After going back on the record, the client said, I'm not confident with my lawyer.
Sir, I'm sorry to cut you up, but I see your white lights on, and I forget the name of the case, but I remember within the last year there was a case from the Court of Appeals, and there was a very significant dissent in the case where it boiled down to whether a defendant's statement that I would love to go pro se, and I realize that's a pro se as opposed to a new attorney. Are there any parallels here where, in this situation where they're asking for a new, defendant's asking for a new attorney, does there have to be a little more meat on the bone to trigger that obligation? Because I believe the majority in that case found that that statement, I would love to go pro se, wasn't enough to trigger the very meaningful inquiry the court is supposed to undertake. And I recognize it was a dissent in that case. Are there any similarities in this situation where the request is for new counsel?
Well, in contrast here, my client asked 5 times for a new lawyer. In that case you're referring to, and I forget the name as well, the defendant said, I'd love to go pro se. That's not
in the pro se cases, we're always talking about an unequivocal statement on the part of the defendant that he or she wishes to go pro se. So it has to be unequivocal. So if you draw that analogy to this case, it does not appear to be any unequivocal statement that the defendant wished to have a new attorney. Rather, it appears that the defendant was unhappy with the trial strategy and with the strategy undertaken by the attorney, and more so that he was unhappy with the rulings made by the court, and more specifically that he was unhappy that he could not get a misdemeanor plea. And you made reference to at some point in time where an offer was made and he said he wanted to take it?
Yes.
When was that?
That was on October 14th.
And what was the offer?
The offer was a sentence of 1.5 to 3. And the court, at page 54 of the minutes, if I can take it today, Your Honor, I'll take it today. I'll take the 1.5 to 3 today. Well, court says, I want you to speak with your lawyer. I want to make sure this is something you want to do. Defendant says, no, I'm fine. I'll take it today. Court then insists, I'll give you 5 minutes. I want to make sure you're confident you know what you're doing. Client says, if we can do this today, we will do this today. They go off the record.
But could he even have gotten 1.5 to 3? I thought he was a valid pred.
He was a predicate. If it was, that would have involved a plea down to a nonviolent offense.
Okay, you have time on rebuttal.
Your Honors, and may it please the Court, Anna Nacho for the people. None of defendant's requests for new counsel warranted further inquiry or constituted good cause for substitution.
I'm glad you started right off with that, because my reading of People versus Porto is the court has to to carefully scrutinize, quote unquote, serious requests. What is a serious request that now triggers that further obligation? I mean, can the fact that a defendant continues on repeated calendar appearances to make that request trigger that make that showing that it's a serious, quote unquote, serious request?
So Porto defines a seemingly serious request as one that has specific factual allegations of serious complaints of counsel. None of defendant's complaints here constituted seemingly serious requests. Many of them were not combined with any specific factual allegations at all. His first.
Is that the case because the court cut off the defendant?
Well, from the record, the defendant does say, I'd like to have a new attorney. The judge does say denied. We don't have the full context of that. Obviously, we're just on the cold record here. But we do know that that comes after defendant's repeated request for this misdemeanor plea. The context suggests that he wanted a new attorney because of that misdemeanor plea. The record does not.
What about this instance where counsel speaks about that he was offered 1 to 3 and then says he doesn't have confidence in his attorney?
Well, so he is offered 1.5 to 3. He does say he wants to take it. The judge says, please talk to your lawyer. And then he says, I'm not confident with this attorney. That is precisely the type of bald assertion that confidence is lacking. That does not constitute good cause for substitution. And
in this case, the defendant indicated that he would take the 1.5 to 3. Then after speaking with the attorney, he does not take the 1.5 to 3. A light bulb should go off.
Well, there was some sort of conversation there, but what the context of that suggests is that he's still wants that misdemeanor plea. It wasn't, the people were never going to offer that misdemeanor plea. But even if he just says, I'm not confident with this attorney, that can't even be seen as a request for a new attorney. He doesn't actually say, I would like a new attorney, just that he's not confident with this one. And
you're saying that on that particular instance, he didn't request a new attorney?
He didn't even request a new attorney. It's definitely not a seemingly serious request. And even if those first 4 requests warranted further inquiry, it cannot be an abuse of discretion because defendant was later allowed to elaborate on his complaints on December, I think it was 6th, and nothing he said constituted.
So you're arguing that I'm not confident with this attorney does not translate to I want another attorney?
Correct, Your Honor. It's not a seemingly serious request for a new counsel. It's just a bald assertion that confidence is lacking.
Are we asking too much of individuals who are overwhelming majority of whom are not lawyers to know exactly what the magic words are to trigger to the court that very, the Court of Appeals has made it clear it's a very serious obligation for the trial court and a serious, right to have new counsel under the right circumstances. Are we asking a little too much of the pro se defendant there to use certain words?
We're not asking too much. All that had to be said was I I want a new attorney. That's not what was said. And then at the next,
That's not fair, because he said that 4 times.
Yeah,
and
he
was
said it
denied.
before.
so
Counsel, are you putting it in context with all of what was happening during the appearances?
correct, Your Honor. At those first 2 appearances, he does say, I'd like a new attorney. But then after that, he says, I'm not confident with this attorney. I do not wish to go to trial. Ralph Shearshawn is representing me. I do not wish to go to trial with this attorney. Those
So
are different.
his statements, I would like a new attorney, don't work, right? And that he's not given a new attorney. So now maybe he's changing tactics. He's figuring, let me use another terminology. Maybe this will work. And I will say, I'm not confident with this attorney.
Even if we consider those to be requests for new counsel, it cannot be an abuse of discretion because he was later allowed to elaborate on his complaints, and nothing he said constituted good cause for substitution.
And on that, I think it was a December date,
I believe it was December.
conference number 5. Was he given an opportunity to fully make a full record and given a full and fair opportunity to speak, to lay out his reasons why he wanted a new lawyer?
We would argue definitely, Your Honor, because he says counsel has been ineffective in, I believe he says something along the lines of arguing all of the motions. And then he goes into a specific motion that he feels that counsel should have argued. That motion was meritless. Counsel is not ineffective for failing to make a meritless motion. And then the judge responds to him, explains why it was meritless. The judge and the defendant then have a back and forth. The defendant says something about, oh, can I file a 440 motion? And the judge responds to that. There is that clear back and forth that constitutes a minimal inquiry in this case and was responsive to defendant's requests. If there are no further questions, we ask that you affirm. Thank you.
Thank you.
So I'd like to begin by addressing the day of the plea offer when my client said, I'm not confident with my attorney. Opposing counsel says that was not a request for a new lawyer. The court certainly thought it was a request for a new lawyer because the court said, I'm denying your request for a new attorney on that date. That was November 8th.
Sir, let me just ask you this. Let's say the first 4 times we find that the judge who was dealing with the calendar that day erred in not making a sufficient inquiry. Would the fact that the judge made the right inquiry on the 5th court appearance, would that wipe away any prejudice or any reversible error based on what occurred at the first 4 calendar appearances?
If the defendant, if my client would have been given an opportunity to explain and been asked the right questions about why he wanted a new lawyer, then yes, I think it would. That you don't need to do a minimal inquiry at each stage at every time it's asked, as long as you ultimately do give the client an opportunity to provide the right answer. But following up on your point before, it's expecting too much of a client who's unschooled in the law to preserve the record for what amounts to grounds for a new lawyer. He was never his initial response was, he didn't make the motions that I want. So the answer to that is, that's a matter of strategy for your attorney. You don't get to choose that. Is there anything else? Are you able to communicate with your attorney? Is there any other kind of disagreement that's going on here? It doesn't require much. It requires a few pointed questions from the court. And this is a client who 5 times before the same judge, it was the same judge throughout these proceedings, is told, I want a new lawyer, I want a new lawyer, I want a new lawyer. One time he's given an opportunity to give the answer, and the answer is not right off the bat. He said he loses his opportunity for that new lawyer. More inquiry is required at that point.
Thank you. 900 8th Avenue versus New York State Division of Housing.
Good afternoon, Your Honors. May it please the court. Rent reductions are for decreased services. That means when there's no decrease in service, there should be no rent reduction. DHCR's inspector
It's a
determined,
reduction in required services.
yes,
Yes. So we started out with a concierge and a doorman or door person, and now we only have a concierge and no door person.
but what we do have is an inspector saying that concierge and doorman are provided 24/7 because one person can provide both of those services.
But in the past, we had two individuals providing the service. We had one who was designated as the concierge and one who was designated as the door person.
Yes,
And now we only have one person who's wearing two hats.
exactly. So when there is a decrease in staff, what you're referring to, that is a presumption that there is a decrease in the service. However, there is a rebuttal, that presumption is rebuttable. And it's rebuttable by a DHCR inspection. And in this case, that's exactly what happened. The DHCR inspector went down there and said, concierge and doorman provided 24/7. 24/7 is the maximum amount of service you can provide, right? Because that means you're saying all day, every day, 365 days out of the year, doorman service is provided and concierge service is provided. There's
How
no
many people are providing the service? Is the concierge also the door person, or?
He's able to, it's like, imagine if there's a busboy and a waiter, right? Are you clearing the table, or are you bringing the food? The answer is I could do both. It's not a problem.
Yeah, so we were talking about multitasking before. However, in this instance where you previously provided the two individuals providing the services, now we have a reduction in the services. And my understanding from the record is there's testimony that the concierge would be doing one thing, the door person would open the door, the concierge is taking packages, while the door person is taking something
Exactly.
else. Someone who is perhaps disabled or in need of assistance.
So the job of the inspector would be to go down and see.
Let me correct you. That inspection that you're talking about, where concierge and doorman are provided 24/7, that was in November 21, 2019.
That was the only inspection that was before the rent administrator.
Right, and according to my notes here, the rent administrator dismissed the tenant's claims at that time, right? And then subsequent to that, complaints came back in again, and then there was a second inspection that went down, and that second inspection had a different finding.
Exactly. So in the middle of the PAR, which is an appeal, they introduced this. They said, oh, we're going to go do a new inspection now. And this time he went down there and said, oh, there's a concierge, but there's no doorman. Completely different finding from his original inspection.
Hold on a second. I just want to make sure that I understand what you're saying. In that original inspection, when they said that there was, where is it?
Concierge
and doorman are provided 24/7. Does that mean that there was both a concierge and a door person?
What it means is, so it was undisputed
Just
that.
answer my question.
No,
does it mean that there are two people doing two different jobs?
No, it means that there was one person doing both jobs. And the inspector found there was no diminution in the service. Had the inspector determined that the one person was unable to do that,
How can an inspector make that determination when
you would
have,
see
presumably you can't have the same person opening the door and handling a package at the same time, where that could have happened if you have two different individuals, right?
I understand completely. So what the inspector's job would be is to observe and see if, as the tenants claimed, was this person being overwhelmed with packages, and was he not able to open the door when people were coming in? That's his job. It is a rebuttable presumption, and it's literally rebuttable by a DHCR inspection. And the inspector said concierge and doorman provide 24/7.
Hold on a second. Just to go forward with my colleague's point here. When that November 21, 2019 report said concierge and doorman are provided 24/7, that was a result of a complaint from the tenants saying that that there used to be both a concierge and a doorman, and there's not, and now there's only a concierge. So that from that complaint, which was in July of 2019, you have a November 2019 where DHCR sends the inspector and says, well, no, there's got to be two. It's concierge and doorman. So there are two people there because the complaint was there's only one person.
No, the complaint was that the service had decreased. They said that.
How do you
complaint
decrease
said
the
two
service?
People became one. Agreed.
Okay.
Yes, that's 100%. Everyone agrees. No one contends that there were two people providing the service when the inspector went down there. The question is whether or not one person could provide both services, like the waiter and the busboy. Can he provide both services? right? And the answer here is the inspector said, yes, they can. If the inspector had observed, as the tenants contend, that the concierge was overwhelmed by packages and he couldn't get to the door, then it would have been in his report.
Was the rent administrator bound by what the inspector found in terms of that conclusion? That's
So,
his conclusion to me,
so
isn't it?
in terms of the rent administrator, there were over 30 allegations, including that they had taken away the complimentary fruit from the cafe. Over 30 complaints. And the rent administrator relied on the inspector for every single one of them except for doorman. It makes no sense. Literally says concierge and doorman provided 24/7, but in his order he says in terms of services provided, concierge is provided 24/7. Wait, if what you're saying is accurate, then why is concierge provided 24/7? It can't be both if they're doing them both at the same time. The answer is that it's two functions. The concierge is I would say very few feet away from the front door. He's able to do both services. This isn't like a 24/7 people walking in and out, in and out, in and out, in and out. Now I can't get to it. And it would have been on the inspector to inspect and determine whether or not that was factually accurate. And it is a rebuttable presumption that if I reduce the staff, so for example, if I had 5 bellboys, now I have 4 bellboys, does that mean the service now is terrible and now there's a decrease in service? Or no, 4 bellboys can cover what 5 bellboys were covering. It's not a problem. And that was the job of the inspector to determine whether or not there was a decrease in service, and he decided concierge and doorman provided 24/7, and the rent administrator, who followed the inspector for every single item, over 30 items, one after another, said following the inspector. Inspector said it was provided, no decrease, no decrease, no decrease. It came to doorman, well, concierge, yes, but doorman, no. How's it possible? Doorman was being provided. It doesn't make any sense. And in a related matter, he also did an inspection when the owner filed a different application to restore the rent because they said the service is provided. And the concierge, the inspector, the same inspector, went down a second time in 2022 and said, yeah, both their services are provided, but they're being provided by the same person. And then in the middle of the par during the appeal, he comes in and says, oh no, there's only a concierge, there's no doorman. Well, that's kind of odd because twice before you said the same person is literally providing both services. And now all of a sudden you're saying that's not true? Obviously, that's not accurate.
So you have time. You can get your thoughts together for rebuttal.
May it please the court, I'm Robert Embarrass. I'm of counsel to Mark F. Palomino.
So the way I looked at this was whether or not there was a reduction in necessary service. You initially had a doorman, you had a concierge. Now you had who were performing 2 separate functions. Now you have one person performing the same functions.
It is possible, as the counsel for the appellant has suggested, that the same person can perform 2 functions, but under these particular circumstances, there was necessarily a decrease in security.
They never got DHCR's approval for eliminating the doorman, right? At least my notes tell me that.
No, they never. No, there was no.
It was always to begin starting off. Just want to make sure there were 2 people, a doorman and a concierge, right? And at some point, the tenants complained, saying, "I only got a concierge." The inspector went and wrote concierge and doorman 24/7, which means to me that the tenant's complaint was unproven, couldn't be substantiated, because. Right? I mean, they're complaining only one person, but when the inspector said doorman and concierge, that can't be one person. There had to be 2 people at that point, right? Contrary to your friend's commentary saying, no, it's one person. It had to be one person.
I don't think there's any dispute, and I don't think that the appellant would dispute that there was in fact, one person at the time of all 3 inspections performing.
I think they conceded it in the record.
Right.
They conceded that although it said concierge
Yes.
doorman, there was only one person.
So
the complaints were based upon security, the door was heavy, individuals who needed assistance in traversing in and out, they could not do so without assistance. Those were the complaints that were made. Is that correct?
Yes, Your Honor, and but I would argue that the strongest basis for the determination is that under these particular circumstances where you have an unlocked front door and a front desk which contains security cameras that monitor other unlocked, unattended entrances to the building, it's not possible to have one person.
That I did not see in the record. Was that in the record?
Yes, I believe so, Your Honor. Yes, there, the security cameras monitored, among other things, the security cameras.
No, I saw that there was an issue with security and compromised the access and security at the building's entrance door, but I didn't see anything in the record that talked about the concierge and or the door person actually sitting there watching the monitors.
There are allegations, consistent allegations from the tenants, both during the RA proceeding and on par, that that one of the duties of the person stationed at the front desk, whatever you want to call that person, was to monitor the security cameras, and the security cameras.
All right, the employee is assisting tenants at the front desk. He or she's leaving the security cameras unmonitored.
Right, and those security cameras monitored, among other locations in the building, 3 back entrances, of which one, the tenants alleged, was not locked, and anyone could gain entrance there and then enter the entire building. So what we would submit is that under the circumstances, there could not have been a decrease in security, because when this one person is at the security desk, at the concierge desk, looking at security cameras, he can't be monitoring the unlocked front door, and vice versa.
Thank you.
Thank you, Your Honor.
Okay, so there was no finding about a decrease in security. Absolutely not. What happened here was that there was an initial inspection, concierge and doorman provided 24/7. In the middle of the appeal.
Sir, when was that inspection?
2019. And then in the
November 2019.
Yes.
Was that over the course of how many days did that inspection occur?
It was a one-day inspection, and it's up to the inspector to determine how many times he has to go back. In the cases cited, it talks about some inspectors would go back multiple days to see what's going on, but it's for the inspector to determine whether or not there is actually a decrease in service as a consequence of a decrease in staff. It is a rebuttable presumption.
This was a question that was, exactly, this was a question that was posed before. Should the court not look to, or should the rent agency not look to when the inspector went, how long the inspector was there for?
If the inspector felt like it needed more time, then he should have done that. That's part of his job, is to ascertain whether or not the decrease
Okay, but
in
if
staff.
the inspector did not do so, is that not something that should be looked at? If the inspector, for example, went to the building, and I obviously don't know that this is what occurred, went to the building at 8 o'clock in the morning, you may not have as much traffic, you may not have the packages and folks going in and out. So should this not be something that they would consider, that should be considered?
So again, they relied on the inspector for over 30 services. Every single service they relied
Mario,
on.
you said 36. You ticked them off, including the loss of fruit wherever.
Yeah, everything. They relied on the inspector. So that's what DHCR does. And they even cite in their papers, we
So
rely
what
on
is
our
then what's the purpose of the rent administrator? Is the
Again,
rent administrator required to accept the findings?
It's not a matter of being required, but DHCR, it is DHCR's policy, and they cited their papers to rely on their inspector. They actually did the inspection during the PAR, which is contrary to their own rules. They're not allowed to inspect during a PAR. It's introduction of new evidence. If there's a new evidence, then they have to remand it back for the rent administrator to consider it in the first place. The owner here had no opportunity to, they had no notice or opportunity to even address this new inspection. But here's the main point here, is that in that second inspection, it's really the third inspection, it's the inspection during the appeal, he just said there's no doorman. It's just not believable. Because on the first 2 times he inspected the building, he said doorman and concierge. And specifically in the second inspection, which is the middle one from the related matter, he specifically says, yeah, concierge and doorman are provided 24/7. It's the same person. And since everyone's conceding that when he first inspected in 2019, that it was the same person, that means he saw one person providing both of those functions, and they were able to do so. And how much time he spent there, I don't know if he maybe spent the entire day there. It's unclear. Could be he spent the day there watching it and see, can they open the door when someone comes in? Can they get to the packages? Is a concierge being overwhelmed by also opening the door or not? Had he been overwhelmed, then he would have put it in his report saying, oh, I saw the doorman, the concierge, and he couldn't open the door because he was busy with the packages. It's not in his report.
Take a breath. Thank you so much. Thank you both. That was very interesting. People v. Marcus Hesseron.
Good afternoon, Your Honors. Glenn Garber for Marcos Jessum, the appellant in this matter. I guess I would start by saying this is a quirky case with quirky facts and also quirky legal issues. And just to kind of summarize, and I know you're familiar with the record, you have a possession of a loaded firearm, but the firing pin is broken, so it's inoperable. And they're still going after him on an attempted possession, so he has to have the intent or the knowledge that it's actually operable when it's inoperable. And there's an alleged menacing of a police officer. That was a huge part of the case. I mean, most of the
He
testimony...
was acquitted on the menacing charge.
He was acquitted, yes.
Yeah.
But that's, I mean, I'm just sort of laying the groundwork because I think that the two issues, so we have two attempted possessions, one with outside of home or place or business, one intent to use unlawfully against another, and the menacing acquittal, in our opinion, basically wreaked havoc on this record and the way that...
Well, that's your, I mean, as you said, that's your argument, that's your opinion. We do not know from the record. There's a reasonable view of the record, of the evidence, that the intent to use unlawfully was not aimed, excuse the pun, at the police officer, that the intent to use unlawfully was in general. And that was the question, that was the question by the jury, and which led to the supplemental instruction by the court.
Yes. So, well, I think we're on the same, I focus on the variance, at least my first point, which I think is an important fundamental point. And the court ordered the grand jury instructions, which I asked for, because I was trying to figure out what that grand jury indicted on. And when I got the instructions, I think it's pretty clear that the grand jury indicted on the intent to use unlawfully being focused on the menacing against the police officer.
Is that what the grand jury indictment said? Did it say to wit, intended to use unlawfully against police officer, whoever the police officer was?
It did not say to wit.
Okay.
There's also a bill of particulars issue too.
And did the bill of particulars say that it was intent to use unlawfully against the police officer?
Well, no. Okay, but the fact that the charge is general in nature doesn't resolve the problem here. You have to look to see what was going on in that grand jury.
Well, there was
how
also
they were charged.
they had also submitted the charge of menacing, right? So you need that information with regards to the police officer for the menacing charge. That he got acquitted of that, that's another story. But in the grand jury, you had to present evidence as to the menacing.
There's a number of reasons why we believe that the grand jury indicted on intent to use unlawfully against another, meaning the menacing of the officer. And it is...
So if that was in fact what was presented to the grand jury, and that was in fact the indictment that was sought by the people, then the indictment would say, to wit, officer whomever, in terms of the intent to use unlawfully, which I have never in my experience seen a charge of criminal possession of a weapon with intent to use unlawfully where there's a to wit as to any individual, because that charge is to individuals at large, anyone, and not to a specific individual. If it's a specific individual, then it's going to be a specific charge, i.e. attempted assault or assault, to wit, that type of thing.
I don't believe the law is that the indictment has to have a to wit clause to narrow or to define more specifically what the grand jury indicted on. And
it may not be the law, but that would be the practice, because then we would have a defendant who says, I didn't know, the indictment does not give me enough information as to exactly what the charges are against me.
Okay, can I back up to the bill of particulars?
Whatever
Because
you wish to
I
do.
do want to get back to this if I can, and I don't think I'm getting to my other points, by the way. But the bill of particulars is so the bill of particulars, which is in the VDF, says look at the complaint, and there's also they identify the time.
So wait, I'm sorry, is there a VDF and a bill of particulars, or is there only because they're two separate documents?
Yes.
Okay.
Okay, so the VDF, the first part says bill of particulars, and it says we rely upon the complaint, and then there's also a time and place of the event. The time and place is an exact time, 5:49 a.m., and the location is the location where the menacing took place. So that is what the bill of particulars says. So the event, so that is a reason why we contend that that is the charge that is before the jury, and to instruct the jury and say, no, it doesn't matter who the intent was against or what the unlawful use was about. That is a deviation from the bill of particulars and also what the grand jury indicted on. The argument's a little convoluted, but I think it makes a lot of sense, which is that here there were two defendants before the grand jury. One was Fernandez, who was just indicted, by the way, on possession outside of home or place of business, even though they submitted unlawful use as to that client or that defendant. And then the grand jury is instructed, and this is the critical instruction here. So as I explained with Mr. Fernandez, this is in the grand jury, there's a presumption which you include in your decision-making. But in that situation, unlike Mr. Fernandez, he's talking about Jessum now, there was other additional evidence that was presented to you, which if you find reliable and credible, could also support the presumption of unlawful intent. You could even decide that he possessed his weapon with unlawful intent without the statute based solely on the facts that you heard. Now, what happens with Fernandez is he's possessing the gun, he then passes it to Jessum, Jessum puts it in his waistband, they walk down the street, stop and frisk men with gun. They stop and frisk them, and then there's a whole other saga that takes place with Fernandez. The cop grabs the gun. They're struggling.
Yeah, and he drags the police officer 2.5 blocks, right? Dragging her down the block as she's trying to hold on to her service revolver, et cetera.
So what the grand jury does is no true bills as to Fernandez and a true bills as to Jessum. The only logical inference from that is that the grand jury rejected the presumption and found that the additional conduct that Mr. Jessum engaged in with the officer was the intent to use unlawfully.
That means that they rejected the presumption as to the person that they didn't indict. That doesn't mean they rejected the presumption as to your client.
Well, it's pretty obvious that given that...
It could be two bases, right?
Excuse me?
There could be two bases, right? There could be two reasons, two ways in how he intended to unlawfully use the weapon?
There could be, but that's not a logical inference from how they broke down that verdict. That verdict in the grand jury is very obvious that it was the additional conduct that Mr. Jessum engaged in that caused him to be indicted on unlawful use of the weapon.
You have
That's
time.
the argument, and
Yes, and you do have time on rebuttal.
Okay.
Good afternoon, Your Honors. Andrew Seawald for the people. May it please the court. I would begin by noting that this entire argument that there was a variance between the indictment and the trial proof was unpreserved. Defense counsel did not make this argument below. That would have been the proper time to argue that the people were somehow asking the jury to convict the defendant of criminal possession of a weapon based on some different theory than what was in the indictment. I would also note that in the people's response to the defendant's request for a bill of particulars, the people noted, people referred to the criminal court complaint. The criminal court complaint described the defendant's possession of the weapon beginning on 135th Street and continuing to 139th Street. That was the entire, and that was the proof that was presented, had been presented to the grand jury and was presented at trial. The trial proof showed that the defendant first possessed that gun on 135th Street. He, at some point, hands it to Fernandez. Fernandez hands a bag containing the gun back to the defendant. As they're proceeding towards 139th Street, defendant takes it out as he passes a group of people, and then and all of that precedes the incident involving police officer Moore as she tried to apprehend the defendant. So there was ample basis for defendant to be on notice that he was being charged with possession of the weapon for that entire period, and and that was what was presented to the grand jury. That was what was presented at trial, and both the grand jury and the trial jury had all of that before them as they sifted through the evidence, decided that there was not proof beyond a reasonable doubt to convict the defendant of the menacing charge, but that in no way undermined the sufficiency of the proof or cast doubt on the.
So what about the instructions given by the assistant district attorney in the grand jury that your colleague made reference to? He made reference to statements as to the presumption and intent, et cetera.
Yeah, well, as I mentioned, the evidence presented to the grand jury regarding the defendant's possession of the weapon was not limited to simply his possession during the encounter with Officer Moore.
So was that ever the theory of the people's case? Was that the intent to use unlawfully, criminal possession of a weapon with the intent to use unlawfully, that the intent was towards Officer Moore only?
That would not have been the people's theory. The people, as Your Honor alluded to, generally would not limit themselves to a theory that the defendant used or intended to use the weapon unlawfully toward a specific person, and there was no requirement that we prove that he intended to use the weapon unlawfully against a specific person. And in the case of a defendant who carried a weapon over a fairly long distance, where we had surveillance video showing him carrying that weapon over that distance, it wouldn't make any sense for the people to have limited their theory to only one portion of that period that he was carrying the gun, saying that that was the only place that he possessed it with the intent to use it unlawfully against another. So for these reasons, I ask the court to affirm the conviction, if there are no further questions. Thank you very much.
Just a few key points on the variance issue. You have notice and you have usurpation of the grand jury function. There's also double jeopardy, but I think for the bill of particulars is the notice problem, and the usurpation of the grand jury is looking to see what the grand jury indicted on and whether or not there was a variance between what they charged and what the defendant was convicted on.
Sir, is your friend correct that that point was unpreserved?
It was unpreserved in part because I did not have the instructions to the grand jury, so I couldn't fully make the argument until this court ordered that they disclose their grand jury instructions. And my read of the law is it's not just limited to the to wit language. I mean, an indictment could say to wit, murder with a gun.
Counsel, when did you get the grand jury minutes?
Excuse me?
When did you get the grand jury minutes?
I got the grand jury minutes. It's just the testimony. So I don't know how the grand jury was instructed, so I don't know what their focus would have been on the menacing and its significance to the intent to use unlawfully against another. And I tried the case. The way that case was tried, although the people did say, oh, it could be anything, it was all focused on that menacing. That was the entire, 90% of the presentation. And this stuff starts to surface during the supplemental charges when it becomes...
So, counsel, in terms of the criminal possession of a weapon with the intent to use unlawfully, if the defendant had simply been arrested at whatever the first location, are you stating that the people could not have charged him with the criminal possession of a weapon in the second degree with the intent to use unlawfully?
No, they could have.
Okay. And so who then would the target of the intent to use unlawfully against have been?
In that situation?
Yeah.
Like in your typical
exactly.
Case? That's why this is a quirky case. It's fine. Less is more, and they're great with that. But once there's more, okay, so once there's something in the
and
grand
so what
jury,
is the more? That's
the more is Officer Moore, by the way. So Officer Moore and the whole event with Officer Moore being dragged down the street.
Yes.
Okay, and she's behind him. He's got the gun. He's running.
Well,
okay?
the menacing goes to that aspect.
That whole
right?
thing.
That's the menacing.
No. But that whole thing is the intent to use unlawfully against another.
I asked you whether whether or not the defendant could have been charged with intent to use unlawfully at the initial location. Let's say it's not Officer Moore. Let's say it's Officer Less. So now Officer Less makes the arrest. again, there's enough for the intent to use unlawfully. So why then do we have to have an individual named?
Well, because that is a very narrow view of what the law is, but not what the grand jury indicts on. So even though there's elements to a statute, if there is something specific that the grand jury is focusing on, they alter the
Trying
charge.
to connect, to create a nexus between the menacing charge and the charge with respect to the attempted possession, right? That's what you're saying, because that's what you're arguing.
I'm making the argument. There is a
Right.
nexus, and it was an obvious nexus. It was as
Is it,
obvious
Counsel,
nexus.
is it a nexus or is it a separate charge? There happened to be a separate menacing, and they were claiming there's a separate independent menacing. If you're going to present that to the grand jury, you have to give them evidence of the menacing. And the evidence was what happened with Officer Moore. So now you're conflating the two and saying that they're tied to the menacing to prove the unlawful intent.
And also, I believe the defendant was also charged with the attempted aggravated assault on a police officer. Which they also acquitted on, right?
And the fact that the menacing charge was acquitted, you're saying that everything else falls.
Well, I'm not conflating in the sense that you're saying. What I'm saying is, how do you a fundamental question?
Sounds like it.
Is, how do you determine what the grand jury charged?
Because we have to. Well, we
Well, I
know
think
what
you
the
do
grand
have to.
jury. We know what the grand jury was charged. We know what the charges were. We know what the instructions were. We have to assume that the grand jury abided by those instructions in rendering its true bill.
But it's not that simple. If the grand jury
But it is.
It's not.
But it
The grand
is.
jury
Thank
is-
you. Thank you very much.
Hung in verdicts in the grand jury is part of your analysis.
Goodbye. Thank you. Goodbye. Fine v. Langer.
Love this job.
Good afternoon. May it please the court. My name is David Schlansky. I represent Irving Langer, the appellant. Thank you for your time today. This is a really interesting and complex case.
I got one question right off the bat. Why should your client be treated any differently from Mr. Berger?
Because my client is different from Mr. Berger in every regard. Because Mr. Berger sued Allegiant Realty.
I'm sorry?
Mr. Berger sued Allegiant Realty, which is a realty operation company in which none of the fraud, none of the misconduct, none of the safety concerns that affect these nursing home occupants or my client's forgery have taken place in. So when Mr. Berger came
Are
forward—
they all under the same operating agreement, though?
They are absolutely not.
It did not involve Mr. Berger's action in Arizona did not involve or implicate any of the operating agreements that are at issue here.
it implicated erroneously that he was complaining about the operations. He sued Realty. Realty has a rabbinic arbitration clause.
Yeah. Mr. Berger was part of the, I mean, he was also a member of the, he was a member under those operating.
This is not where the chicanery that we're talking about here is going on. It's going on in the operations. There's a distinction in nursing homes between the Realty. Well, hold on, because if
I'm
you're
listening.
So with corporate entities, they are segregated. This is a fundamental precept of New York law. Taxi cabs, buildings, nursing homes, you can have different operations, and there's a reason for that. And one of the reasons for that is because there are contractual obligations that pertain to those dealings. In this case, all arbitration arises from contract law, consent. And so there has to be consent to a competent authority to oversee things. So there's a separate issue which relates to safety, police power, and fraud. Arizona law captures those in Arizona. That's
Counsel, unless I'm misunderstanding or misreading the facts here, Mr. Berger discontinued the action in Arizona to go to arbitration. All the parties just, at that point, that was it. They wanted to go to arbitration. After that, now, we turn the page. Your client now litigates in Arizona, right? And everyone's saying, wait a minute, we should be going to arbitration because, you know, we all told Mr. Berger and said, you got to go to arbitration. You can't commence this action in Arizona. And he did, and he relented, and now you want to commence an action in Arizona, and you don't think you should go to arbitration?
Because Berger sued Allegiant Realty under Allegiant Realty's provisions. He sued specifically under that operating agreement. That operating
Well,
agreement.
if that's the case, then why would he, that you're saying that that's the reason why he gave in and threw in the towel and went to arbitration?
He was compelled to go to arbitration. He was on the verge of being compelled to go to arbitration because he was complaining about matters within the ambit of the realty company. Langer is not complaining about the realty company.
Well, sir, in your view, then, which of the various agreements controls here and dictates whether you can pursue the Arizona action or must participate in arbitration
Well, first
here?
off, the police power controls. Arizona has dignity. It has comity. The state court system has comity and has an obligation to allow Arizona to govern fraud, forgery, misconduct, mistreatment of occupants within Arizona. So first off, that's part of it. But secondly, Allegiant C clearly compels that there is Arizona law applies, and it says that courts apply, but the courts that apply are governed by Arizona law. Arizona courts say, and I was in an Arizona court last week, that Arizona law allows this to be heard in an Arizona court if Arizona law applies, regardless of whether it says New York venue.
So in your view, the agreements don't matter in this regard. Your client's free to go to the Arizona courts.
The agreement is interpreted under Arizona law, and the Arizona court says that we will hear this matter under Arizona law. That's what Arizona law means.
Which agreement are we talking about at this point?
The Allegiant C operating agreement, which is the 2017 agreement. So when you get to the question of why is Langer not bound by what was said when Berger sued? First off, Berger sued on different subject matter. It was different. In some ways it was smaller, in some ways it was broader, but it related to realty. He also specifically sued in regard to realty and the operating agreement, which Langer is not doing. By the way, that operating agreement also says that any issues pertaining to it are to be heard by an Arizona court. So it's in the wrong place in either regard. So if we're going to go ahead and say, if somebody is suing about operations, but because there's a parallel LLC, and you're going to jump the track and by osmosis assume that because a parallel sister company has a different provision, there's no way that could be contractually an assent to that contract.
You have time on rebuttal.
Okay.
Good afternoon, Your Honors. May it please the court. My name is Michael Daxon. I'm here today on behalf of the respondents in this appeal. The motion court correctly compelled arbitration of appellant's claims in this matter.
Is it accurate what your friend has said? It's like, there's two different things going on. It's not related.
So
Whatever happened to Mr. Berger should not be imposed upon my client. What do you say to
Exactly.
that?
It's incorrect for several reasons. First, as relates to the Allegiant Realty operating agreement, the motion court correctly found that operating agreement had an arbitration provision which was broad enough to cover all these claims that involve the intertwined LLCs. In fact, some of the causes of action themselves do necessarily involve Allegiant Realty, including appellant's claim that he was induced to make a $7.9 million investment into that entity, as well as allegations that are tax assessments against that entity. So a lot of the claims do have to do with that entity specifically, but even the other entity that's involved, the motion court correctly held that the arbitration provision itself was broad enough to encompass those. And then as well, the Allegiant C operating agreement, which my colleague on the other side only refers to the 2017 version. The 2017 operating agreement was not signed by the appellant. He only signed the 2016 version, which included the arbitration provision. Appellant wants the court to decide that that was a superseded agreement. However, he did not sign the 2017 agreement. A majority of interest was allowed by the 2016 agreement to amend the operating agreement of Allegiant C, but that doesn't give them the authority to go ahead and supersede the entire thing without the signature of all parties, including the appellant. And as such, the motion court properly found he didn't sign that. How is he going to use that, against our arbitration here as well?
Specifically, did the trial court enjoin or stay by virtue of her order?
The Arizona action, that these claims belong in arbitration, and as such, there was no basis for the appellant to bring the Arizona action.
Can one state stay the proceeding in a sister state?
Yes, because here there was a mandatory arbitration provision and there's no public policy at issue.
What if Arizona law said we don't recognize that, and so the action is properly here?
There has been nothing on the record saying that Arizona law has any issues with that. There's been, a vague reference to the interests of the state of Arizona, but ultimately, as the motion court found, this is really a dispute between two private individuals. It's not involving the police power of the state of Arizona or anything like that.
Although they have a significant interest in how nursing homes are run in their state.
Certainly they may, but at least at this point, the arbitration provision should control because of the strong public policy favoring arbitration. If I may just to turn briefly to two other matters, in terms of the Rabbi Feiner, who was the arbitrator listed in the operating agreement. First of all, he didn't even say that he refuses to take it on. He said in an email that he's busy during a certain time of year, and those days are he might not be able to make it work. He didn't.
He also indicated he thought it was particularly complex and might take up a lot of his time, or does that tie into the?
Correct. That ties in.
Use the word timing. The timing of the email.
Coincidentally, it's this time of year again. The time before Passover, the rabbi is very busy with multiple obligations having to do with the holiday. So he was unavailable at that specific few days, but he was not refusing to take the case on. Also,
let's say he had. Let's say he did refuse. Would that be fatal to the arbitration agreement?
No, because there was nothing that made it that it had to be him.
So why did they specify him?
They specified a rabbi that they both agreed to, but CPLR 7504 allows the court to replace the arbitrator if needed. And the lower court's order saying that he is not essential to this was not even appealed by appellant. It's not even before this court. The lower court, the motion court correctly found that Rabbi Feiner specifically was not a requirement to allow arbitration to go forward. And then briefly, just as far as the settlement agreement that is brought up in the papers, but it doesn't even address the motion court's correct finding that there was no reasonable justification as to why appellant did not proffer it sooner. If there are no other questions, I'll rest on the brief and request that it be affirmed.
Thank you.
Thank you.
So I've heard that these entities are intertwined, and they are, and that's a reason why they need to be segregated and kept to their own domains for their particular purposes. Realty is in realty, operations is in operations. If misconduct occurs in operations, if it occurs in Arizona, that's not something.
I got something that I got to ask you. So you're saying that your client's claims arise out of the 2017 operating agreement, right? Which doesn't have an arbitration clause in it.
That's correct, sir.
Right. So that by that notion, then you're free to litigate in Arizona.
Yes, sir.
Well, what if the claims arise out of the 2016 operating agreement? Then you would arguably have to arbitrate those.
That is
perhaps,
arguable.
Right? So then the question becomes, because the case everyone's looking at, Primex International, is a really complicated case. You got to unpack that case. And what it's saying there is you have a merger clause in your 2017 agreement, right? That doesn't necessarily mean that the 2016 agreements are gone. The only way they're gone is that if they try to vary or try to explain, in other words, pro evidence for the 2017 claim, the merger clause prevents that, right? Because Primex is
ways to the same
so
place.
much going on in Primex, that case.
Yes, sir, but they both get to the same place. First off, the agreement was superseded in total, negated the prior agreement.
Which agreement is superseded?
The 2017 agreement was adopted by a 75% supermajority. Right. You don't need to be a signatory. The party to be charged has to be a party.
So you don't need the merger agreement. You don't need the merger clause. That was it.
Well, it's not just a merger clause. If you look at the agreement, it actually supersedes it in total.
Right.
You're saying it was binding on you, even though you didn't, your client, because of under the terms a sufficient number, sufficient portion of the members did.
Right, and you would want that because that doesn't have the arbitration clause.
It's just like any other corporate operation. If you have a 51% majority, the other stockholders are bound. But it's any corporate governance. This is an internal affairs issue that's really clear.
Thank you. Thank you both.
Thank you.
Upper Plaza versus Wang. So first, my apologies. It's my understanding that appellants want to split the time, and I had given you 6 minutes. And so, Mr. Wang, you wish to argue for 3 minutes, and your attorney wishes to argue for 3 minutes as well. Is that correct? No. Well, here's perhaps my first question is, what is your name?
May it please Your Honor, my name is David Wood.
Okay, so thank you. The motion court disqualified you based upon the motion by the defendants, right? Excuse me, plaintiffs moved for your disqualification because you had previously represented the plaintiffs. Is that correct?
That is correct, but you did.
And then you appealed, but then you withdrew your appeal. I have the appeal as, well, I'm sorry.
Mr. Sampson attempted unsuccessfully to disqualify me before this most honorable court.
Okay, you appealed from the order by notice dated November 15, 2021. We denied the motion. So as far as our record is concerned, you were disqualified.
That isn't correct, Your Honor.
Why is that not correct? The lower court it granted plaintiff's motion to disqualify you, as you had previously represented plaintiffs in a related action in Queens County.
That is correct, Your Honor. The lower court disqualified me. However, when I made my appearance before Your Honorable Court here in the First Department, after having expended extreme...
You're talking about like an hour ago?
No, Your Honor. If you would check the record, Mr. Sampson made a motion to disqualify me, sanction me, charge me attorney's fees, and...
So all I'm trying to find out right now is what your status is, based upon the lower court's disqualification of you from this case. Please.
The lower court disqualified him for simultaneous representation conflict. He then filed an interlocutory appeal. The court then entered final judgment, so he withdrew the interlocutory appeal, which is normally the case when a final judgment's entered. He then filed the brief, and we brought a motion, which is, wait a minute, he was disqualified. The court denied it without prejudice to bring it up for argument. So that's the facts. I'm not sure what it means. Is the lower court order still outstanding or not? I mean, it may be moot because of the substantive issues.
Yeah, you have a judgment. I guess the court entered judgment of disqualification, right? Because that's why he withdrew his appeal of the order disqualifying him, right? Because there was an order disqualifying him, a judgment was entered, he withdrew the appeal from the order, because, right, necessarily the judgment extinguishes the order. And there was no appeal of the judgment now that sets forth the disqualification, right?
No, there is an appeal of everything.
Oh, okay.
Of the judgment as well?
Yes, Your Honor. There's a whole long laundry list.
Okay, right, order and judgment. Okay.
This is an appeal from a final judgment in which I entered.
Part of the judgment included your disqualification?
Correct, Your Honor. And originally, Mr. Wang had come in pro se. I contacted some authorities, including this honorable court, and was told that I wouldn't even need to make a motion, that I would be allowed to come in and defend myself and even defend Mr.
I do not know whether that is correct or incorrect, but what we are going to do is we will proceed. You can argue. But I'm not going to split the time.
I understand.
Either you are representing him or you're not representing him, okay? So you decide who's going to argue.
If I may ask, Your Honor, Mr. Wang is actually extremely capable of arguing.
So then Mr. Wang is going to argue.
But if I may stay here so that in the event that...
You can have a seat. There are plenty of chairs.
No, my question is...
You can sit over there. You can sit wherever. You can sit right there at the table.
Yes, Your Honor.
Why don't you sit over there? Great. Thank you.
Good afternoon, Your Honor.
So, my please court, my name is Ken Wang. I'm an attorney, and also I'm a defendant and appellant in this case. You know, this is one of my horrible experience in my life. So, unfortunately, so bring a lot of issues and before this court for this case. So, among others, so we filed the brief and reply, and among others, the most important argument for us to make today is a plaintiff respondent have no standing in this case because they allege they are sole member and managing member on behalf Clean Air Car Service Parking Branch 2 hereafter.
I don't have an issue on appeal as to standing. I thought the issues on appeal were as to venue as well as granting plaintiff's motion, granting judgment for plaintiff based upon your alleged refusal to turn over books and records.
So, Your Honor, I think maybe some misunderstanding. So you can check our opening brief. We raised the no standing, plaintiff no standing, and the lower court have no jurisdiction, and the contempt order for contempt should be reversed, and then disqualification should be reversed, and I get a bias by the lower court. They give me less than 1 day to file the opposition for summary judgment.
Okay, so let's take it one at a time then. The lower court, the motion court granted plaintiff's motion judgment, granted plaintiff's motion for judgment based upon your alleged failure or refusal to turn over books and records that were still in your possession. Why was that incorrect?
So first of all, this case, who is plaintiff? Plaintiff is Clean Air Car Service Branch 2. We hereafter call Clean Air 2. So under our Plaza. So under the operating agreement of the two companies, this is the no dispute from the plaintiff appellant. The operating agreement is valid. Under the operating agreement, very clearly, if anything related to, in any way related to operating agreement, the case should file in Queens County. Therefore, the first reason is the venue that the cases should file in Queens. That's one. Second is nobody from the plaintiff, whoever, either the Clean Air 2, their property in Queens, or Plaza in Queens, and the Reno, never in New York County. So the address they provide by the Reno or the sole member, they call CVCF Reno, they provide fake address to gain the venue in New York County. These are the mistake, no mistake. It's 9 months. The address does not for any relevant to plaintiff. They claim they are New York company. Actually, they are not New York company. They are the Delaware company. They said the address in New York is correct. No, it's not. Nobody, any connection with the address when file the lawsuit. So therefore, this is the venue absolutely is
So this is your argument that venue is properly in Queens and not in New York County?
That's correct. Based on the stipulation, so both parties stipulate. So anything that in the operating agreement, and then you can see their brief, they on the old record, no one to dispute operating agreement is invalid. Therefore, all the party should follow the operating agreement to do anything, including litigation. This is the venue. Second part is
counsel. I mean, that presupposes that the purchaser of the entities is bound by the operating agreement, right?
Both.
Right. No, the operating agreement that you're relying on that says venue should be in Queens County. You're relying on the operating agreement, right?
Yes.
My understanding is that the plaintiff here is the bona fide purchaser in a UCC sale conducted. Took over the two entities, and the only way that your argument would fly would be that they're bound by the operating agreement. The operating agreement can't bind them because they never were members of the entities. They didn't sign off on the operating agreement. They just bought the companies. So they could enter into their own new operating agreement.
Okay, Your Honor, with due respect. So you will see the bill of sale, the subject to operating agreement of the two entities. You can see the operating agreement.
But did you not sign an agreement, did you not execute an agreement that upon default you will be resigning and turning over your membership to the entities?
Your Honor, so that's the, I need to address the issues. Under the section 4.2 of pledge agreement, that's only limited to very specific circumstances. So you can check the record 126 and the record 169 of the pledge agreement. That's many people confused with the issues. Let me clarify. So in order for me to amend the operating agreement to recognize the lender or its nominee to become member, the lender should send notice to me, and the I agree to amend the agreement to accept them. That's the, however, the lender in this case did not send notice to me, so therefore, this court, that what you said, does not apply. The lender select to sell this, the collateral to the through UCC directly without send notice to me, to based on the section 4.2, record 126 and 169. That's
Thank
one.
you. You have time on rebuttal. Thank you.
Thank you, Your Honors. May it please the court, Paul
Could you
Sands.
address the venue issue first, please?
Yes, the Supreme Court correctly found that venue was in New York in an opinion dated August 20, 2021, determining that the pledge agreement provision for venue controlled, and the pledge agreement had a agreement to venue in any court in New York. The dispute is, what does the pledge agreement say? It's between us and Mr. Wang as to what our rights were under the pledge agreement. We, the client and the court too, viewed this as a fairly straightforward case. There was a $12.3 million loan. There was a default. The loan matured, not paid. UCC sale, credit bid, and the UCC.
So his reliance on the operating agreement is not the operative agreement, right? It's the pledge agreement.
Pledge agreement, and I can.
Because he was trying to, and I was trying to understand that a purchaser doesn't necessarily, when a purchaser buys an entity, they're not bound by an operating agreement. It's brand new. I do whatever I want with it. I could create a new operating agreement.
Well, it was his equity that was purchased.
Okay.
So I want to acknowledge that. But
it seems to suggest that in the pledge agreement, or as he's phrased it, the bill of sale, it stated that it was subject to the operating agreement.
Every LLC.
Meaning venue, the venue clause. What he just stated was that the bill of sale, which is the pledge agreement, was subject to the operating agreement, and the operating agreement spoke of venue as Queens County and not New York County. So is there anything in the bill of sale or in the pledge agreement that so referred?
Well, the pledge agreement, which is what the bill of sale is under, the pledge agreement provides in numerous places. Well, it specifically provides, and that's what the Supreme Court relied on, that the action can be, an action can be brought in any court in New York State, and that's why the Supreme Court denied their motion to change venue. I would also point out there's been no prejudice to the defendant, and the defendant himself had chosen New York for the first case, where the defendant brought suit to enjoin the foreclosure. The New York Supreme Court denied that for lack of likelihood of success. Then the credit bid purchaser, after completing the purchase, brought this action to get the books and records. We are very simple. You buy it at the auction sale, you need the books and records to run it. And that's how the case started out. This is actually, their big point was the managerial rights, and they claim that the plaintiff doesn't have managerial rights. But that's contradicted extensively by the pledge agreement, and that was expressly pledged. I don't think that the bill of sale said anything other, it didn't incorporate it by reference. All it was saying is you've got the equity of an LLC, and you get what with an operating agreement, and that's what you now own. That doesn't mean to say that disputes about whether the secured party could sell the managerial rights were subject to venue in Queens. It only said disputes between members need to bring the action in Queens, and as the Supreme Court found, once Mr. Wang resigned by virtue of the default, he wasn't a member. So he has no standing to say after the default, because there was a default and a secured party, so no matter what county you're in, he doesn't have standing to rely on the operating agreement because he's not a member anymore. And his resignation is attached as an exhibit to both pledge agreements. There's two entities here. And there was also a provision that says that the lender can amend the operating agreement to basically kick him out as a member and come in as a member. To file an amendment to the organizational agreement of the company, admitting lender or such nominee as a member, partner, or shareholder in place of pledgor. And then there's handwritten notes. I'm on the record, page 307, with handwritten notes that are too small for me to say, but
Record 307, we have it, thank you.
and speaking of record, I discussed this with the clerk's office, and they suggested I flag it for you. There have been multiple appendices filed and record appendices filed and returned in this case, and when we prepared they were returned for technical issues, and which is eventually cured. When we prepared our brief, we used what we thought was an appendix that was the same throughout. And it turns out when I was reviewing it yesterday to get ready for the argument, that the last appendix, the record appendix, is different than the first record appendix, and all of the plaintiff cites in the brief are off by a few pages, some as many as 25 pages. So
noted, thank you.
Thank you, Your Honor.
Your Honor, so plaintiff appellant did not dispute the bill of sale is subject to the operating agreement. The operating agreement is applicable because they buy the membership. So I supplement my answer to the owner who asked me, they are good faith purchaser. Actually, no, they are not good faith purchaser. Like I replied that in my paper, they only pay $100,000 for the property value at $18 million. They buy the collateral subject to a mortgage. So therefore, they did not pay the value. So, and the lender is affiliate of the buyer. The seller issued the instruction for winning price. That's called the conspiracy for the public auction. So based on this part, they are not good for purchaser. Therefore, they have to subject to that right, my right. So
Were
in
these
my,
arguments made before the motion court?
this is the argument that the motion court did not talk about the operating agreement. This is the motion
The
court.
arguments that you just made in terms of the sale and whether they were bona fide purchaser, et cetera.
I change venue. I motion for change venue. The lower court said that this case is nothing to operating agreement. Therefore, I have to appeal this court to raise the argument. So you look
So
at
you did not raise this argument below?
Yeah, because they don't allow me. They said this is nothing related to operating agreement. It's nothing related to the market right. I said, no, this is really market right. They almost get sanctioned me. So this case is a dispute is market right. How to decide market right? Of course, is operating agreement. With due respect to Your Honor, so this case, the issue is who had market right. In our reply brief, very clearly to address the issues about I keep the market right because the deal is the price agreement and the operating agreement both offered by the lender. I
Thank
just
you.
accept it.
Thank you very much. Thank you both.
Yeah, thank you.
The next matter is People v. Marie Vasquez. Justice Michael is recused on this matter. Take care.
Good afternoon. My name is Danielle Bernstein from the Legal Aid Society, and I have the privilege of representing Ms. Marie Vasquez. At 21, Ms. Vasquez found herself in the middle of a barroom brawl against 6 men. In her interview with probation prior to sentencing, she informed them that she had acted in self-defense.
During the allocution and during the period of time during the allocution when she pled guilty, did she mention any self-defense?
She did not, Your Honor, but the position that we're advocating for here is that her statement in the probation report triggered the court's obligation to make a further inquiry as to whether she was pleading validly. And that's because, the suggestion of a justification defense in general triggers that obligation.
And the failure of the court to do so, where is it? Do you have any cases to support your position that a court at time of sentencing is required to inquire at that time as to any defense?
Absolutely, Your Honor. In People v. Beasley, the Court of Appeals, which is a 1969 case, held that this obligation applies for anything that occurs between the plea hearing and the imposition of sentence. So this applies throughout the proceeding until the actual conviction is.
And that case stands for the proposition that the fact that the court, after seeing the pre-sentence report, did not inquire as to as self-defense requires vacating the plea and sentence?
It didn't stand for the proposition as to the probation report, Your Honor. I interpreted your question to mean, does it apply beyond the plea proceeding itself? But as to the probation report itself, our position is that the probation report is a part of the sentencing proceeding for several reasons, beginning with the fact that the criminal procedure law requires probation reports for felony conviction sentencings. That's in section 390.
Unless it's less than a year, right? Unless it's a year or less. If the defendant's going to be sentenced to a year or less, you don't need a pre-sentence report, do you? And if the defendant waives the pre-sentence report.
Well, here the defendant did not.
No, I'm just saying that there are circumstances under which the pre-sentence report is not required.
That's correct,
If
Your
it's
Honor.
1 year incarceration or less, you don't need a pre-sentence report. And or if the defendant waives, you don't need a pre-sentence.
But the reason that it's part of the sentencing proceeding is because in combination with the criminal procedure law and the Court of Appeals is holding in Selikoff, which...
So my point was that you won't always have a pre-sentence report, and since a pre-sentence report is not always required and it's not something you will always have, I don't know that you can actually state that the court is bound and must rely upon any statements in the pre-sentence report.
But when the pre-sentence report is part of the case, Your Honor, then the court is, because then the court is on notice from reading the pre-sentence report as to a potential justification defense, as Ms. Vasquez raised here. In this specific case, the plea court made it a specific condition of the plea and sentence that a pre-sentence report would be generated. It made it part of the proceeding by requiring it, and the parties in the court didn't waive the pre-sentence report. Defendants can waive statutory rights all the time. Ms. Vasquez didn't here. That makes it part of this proceeding. And under the criminal procedure law, and again in combination with Selikoff, the Court of Appeals prevents sentencing courts from exercising discretion until they have evaluated that probation report.
So the defendant pled guilty before the court. The court allocated the defendant as to the incident. The defendant never raised any issue as to self-defense or stated that she was acting in self-defense. Is that correct?
That's correct, Your Honor, but the point here is that the court would have been on notice of it from having read this pre-sentence report that it is required.
So what about the fact that the court would have been on notice from it, from the fact that after her arrest, the defendant made several statements to the police, including, we were just looking to cause some SHIT and start something tonight. Would that not possibly put the court on notice that there was no justification defense that was going to be interposed by the defendant?
Your Honor, even if the defendant in any case says something potentially admitting guilt in an initial statement, if in a later statement the defendant says something that in this case is unequivocal.
And that later statement is after a full allocution by the court of the defendant as to the charges. So we have these statements to the police that they wanted to start some SHIT. We then have an allocution by the defendant wherein she admits to the assault and does not talk in any way that she did so, that the assault was occasioned by or that she was acting in self-defense. But then down the road, we have a statement to the probation officer that she was acting in self-defense, a justification. This means that the court must now do what? Inquire of the defendant as to whether there was a justification defense?
Inquire as to whether the defendant understands that she has the option to raise that justification defense, and she's waiving that option by pleading guilty.
She's already pled guilty.
Yes, Your Honor, but the issue of whether she says it after the plea is not a pertinent question because Beasley stands for the proposition that the defendant could call that into question at the sentencing proceeding. The issue here is whether
would the proper procedure be vacating the plea, move to vacate the plea?
Well, that's what I was asking. So what is it that you would want? What is the consequence of the judge's failure on based upon your argument, failure to address this issue from the pre-sentence report?
So typically the proper remedy is vacator. We're asking here that the court
Dismiss the indictment.
Yes, Your Honor, and that's
you want to dismiss the indictment because
this is a 7-year-old case where Ms. Vasquez already served her sentence, and frankly, the fact that the prosecution offered essentially a non-incarceratory
So you want to dismiss the indictment not based upon the record, but
in the
based
interest of
upon
justice, Your
mitigation.
Honor.
Okay, thank you.
Thank you.
Good afternoon, Your Honors. Jared Walkowitz for the people. Your Honors have already decided this issue many times before. There's two aspects to this court's prior rulings. One where they don't even discuss, which is the preservation issue, that they never moved to withdraw their plea, and this certainly is not the rare case. This court has decided
Well,
that.
the court never made reference to the pre-sentence report at the time of sentencing, right?
Right, but she could have moved to withdraw her plea in terms of the attorney. She's there with an attorney at sentencing, and if she moved to withdraw her plea, she would have been heard. She didn't do that. Lopez says only in the rare case. This court has distinctly and explicitly decided, and we cite those cases in page 7, People v. Grant, People v. Rojas, People v. Wilson. Second.
Sorry, sir, but between the plea and the sentence, was there a reasonable period of time within which the defendant could have made the motion to withdraw the plea?
I mean, there was enough time to do a report, so I don't remember the exact time in terms of days, but they did a pre-sentence report, so there would obviously have been some time if the defendant or defense counsel wanted to raise that motion.
Right, but the defendant and the defense attorney are not given the pre-sentence report until, at the very earliest, the day before. It's normally right before sentencing takes place. So that's the first time that the defense would have seen the statement in the pre-sentence report that she was acting in self-defense.
This court has seen that issue many times before and has obviously felt that there is still time between those two time periods for the defendant to raise that claim. Also, on the merits, Your Honor, one of the things the defendant did not say, and I wrote this down over and over, is the defendant in this case was under oath. The defendant was not under oath.
I wasn't sure about that because I was going to question whether the allocution, which was under oath, she does not mention anything in terms of justification, but the pre-sentence report where she's not under oath, that's where there's a statement.
That's correct.
So this plea was taken under oath?
Yes. And I would also remark, not only with the statement, the final thing I would like to say, not only the statements that you discussed before, Justice Weber, about after arrest, the court saw a video in this particular case of the incident itself and said that they was very reluctant to give this defendant a non-jail sentence. Obviously, if there was some sort of any colorable claim of justification on that video, I think the court might not have said how horrified it was by that particular video. So, Your Honor, I think the court has, the reason why the cases come out the way that they do from this court is because time after time, this court places the emphasis on under oath statements as opposed to what the defendant says in an extradition, in an out-of-court statement to a probation officer.
Thank you.
Thank you.
First, as to the video, it's irrelevant what the court thought of the video of the incident, which is not in the record here anyway. What we have to go off of is what the defendant thought in entering her guilty plea, and what her plea is contradicted by the record here, and the record is all we have to go off of. In terms of the issue of it being under oath, the pertinent issue here is actually whether the report is part of the sentencing proceeding and whether that triggers the duty to inquire. There's no case that stands for the proposition that whether the defendant said it under oath is the relevant thing that triggers that duty. It's about whether she says something in between the plea and the imposition of sentence that triggers that duty. Now, as to preservation, the point of preservation, as explained in Lopez, is to ensure that the lower court has the opportunity to address the potential issue. Where an issue is obvious, the court has that opportunity. And here, where the court ordered a pre-sentence report, reviewed it as is required by law and Court of Appeals precedent, it was obvious from this unequivocal statement that the court had the opportunity to address this issue, and therefore the purpose of preservation is not jeopardized. And finally, Your Honors, I just want to say, if the only difference we're talking about here is that Ms. Vasquez had to say this standing at defense table, as opposed to saying it in a document that the court is required by law to order and read, it just goes to show how artificial a distinction this is in a situation where the stakes are unbelievably high, where the issue is whether she is going to plead guilty, have a criminal record, or exercise her right to go to trial. And so, that's what we're talking about here. It's our position that the report is inseparable from a felony sentencing proceeding, and this court should therefore reverse. Thank you.
Star Indemnity versus Marty Carlo. No. Only certain judges do it. Yeah. Only certain times.
Good afternoon, Your Honors. The motion court committed two pure reversible legal errors at the exact same time when it denied Dorchester's cross motion.
I'm sorry,
I represent the appellant, the insureds. The motion court committed two reversible errors at the exact same time when it denied Dorchester's cross motion to dismiss Starr's affirmative defenses. Carbon copies of the identical legal defenses to coverage this court previously dismissed on the prior appeal when Dorchester pled them as direct claims in its amended complaint. And Your Honor, Justice Weber was on the panel. The first legal error the court committed was
reminding her,
I heard Your Honor make a joke last week about not remembering what you had for dinner last week.
Remember this one.
I remember this one because this is a morass, which, go ahead.
It is
Let me ask you a question. I got a couple of questions.
Thank you.
So you represent Dorchester, the policyholder, right? So the prior decision, I think, if I unpack it, says several things. The first thing it says, look, the policy is in full force in effect, right? Second thing is, in the substance, it granted you summary judgment on your first two claims. One was that the breach of contract by the insurance company, and the second one was a declaration that there was a declaration. Oh, Jesus, I had it right here. It granted you summary judgment on the second counterclaim, which was for a declaration that there was coverage, right? Something like that.
That's correct.
And also, in that second counterclaim, you also saw indemnity for all the claims that you submitted, correct? That's the second counterclaim, if I have
That's correct. In the first and the second, we sought the same thing.
So we're good to go there. So then the decreto now says virtually almost the same thing, except it gave you indemnity with respect to the Sandy claims and the fire claims. Didn't give you indemnity to the Montefusco or the Nunez claims, or what other claims that you have tied in, right?
That's correct.
Which kind of explains to me why you continue the litigation, because you didn't get everything you want. You got Sandy, for your purposes as the policyholder, Sandy and the fire are done. That's it. I got defense coverage and I got indemnity. We're good to go. But with respect to the other remaining claims, I got to keep going, right? Because I want indemnity. Not to mention, you got to provide me coverage. But what's coverage if I don't get indemnity for the claims, right?
That's exactly right.
Okay.
So the policy.
So that now, when you're moving to dismiss the affirmative defenses now that they are asserting, in my mind, then, all the affirmative defenses that have to do with coverage issues really don't belong, right? Because that's where you made a cross motion to dismiss only certain affirmative defenses, not all the affirmative defenses, correct?
We didn't move to dismiss all of them because we have a new fourth counterclaim. And
Right.
some of the affirmative defenses are legitimate to the counterclaim.
Right, right. And also, some of those affirmative defenses may also go to a defense to indemnity, because that's still something you're litigating, whether or not you're going to get indemnity for those remaining claims, correct?
I don't think that's right, because the court granted us summary judgment for breach of the policy. And all 5 claims were covered claims under the policy, and all of the coverage defenses were identical. The coverage defenses to the Montefusco and Nunez claims, they're in the disclaimer letters in the prior record. My
Well, it
adversary...
depends on which aspect of the decision you read. If you read the decretal, there's a limitation. If you read the body, if you will, of the decision, there is no express limitation on the court's holding.
Right.
That's exactly right.
So we're stuck with the decretal, which gives you only indemnification for Sandy and for the fire. The other ones, you can't. You don't have indemnification
You
for them.
disagree? You don't think?
I disagree. There is an order of priorities for resolving discrepancies between the decisional and decretal language of an order. The decisional language controls, and in the decisional portion of the order, the court dismissed all of Starr's coverage defenses, including those...
Why'd you continue with the lawsuit? Why'd you continue litigating? If that's the case, if they taking what you're basically saying, I got a slam dunk. It ends. So why did you continue litigating it?
Because Justice Reed ruled below that we need to reprove liability for the Montefusco and Nunez claims, even though this court granted us summary judgment on liability for our breach of contract claim.
Right. And what was that based on?
What was what based on?
What is his decision? What was that based on? Was that based upon our decision?
It was based on the conflict between the decisional and decretal provisions of this court's order, which is my third point on appeal. We've asked the court to clarify that ambiguity. Because if you look at the logic...
Could you point to us a situation where one panel has clarified the order of a prior court? Not that we indicate we no longer follow a legal holding or that something is...
Exactly, because I could not understand why there was not a motion for clarification. Why you did not make a motion to us for clarification?
Well, we waited a year below to get a judgment from the lower court, and we submitted a proposed judgment that would have included indemnity for Montefusco and Nunez. Finally, we got a judgment that didn't include it. We made a motion before Justice Reed to clarify that liability was resolved for Nunez and Montefusco, and he denied that motion.
Well, in fairness to Justice Reed, he may have been uncomfortable purporting to clarify what the appellate division did.
I think that's exactly right. He's been...
And so if you had made a motion to us to clarify, it would have been completed in 10 days.
And did you appeal Justice Reed's decision on that motion that you made?
No, we did not. We did not because we were off on a new fourth counterclaim. We have a full record before this.
I understand that you have a full, but when Justice Reed said no, you need to continue litigating Nunez and Montefusco, that should have been appealed, right? I mean, don't you think that would have been appealed? If you think that you had a slam dunk, you take that appeal, and that would, if we agree with you, that would have been reversed, and you wouldn't be standing here right now.
CPLR 5019A says that an appeals court can correct a mistake or ambiguity in an order on
You're absolutely right. And so what I'm just asking, and maybe others have indicated as well, what's the authority for one panel on a subsequent appeal to make the clarification to an order of a prior panel?
I haven't found a case like that.
Ain't
but
there.
The fact is, this case is all about law of the case, and the law of the case argument brings up for review what this court decided on the prior appeal. That is at the heart of this appeal.
And if we can
And it's the ambiguity that my adversary has seized on to now argue that he can replead all of his coverage defenses that this court
I agree.
dismissed.
You know what? I agree with you in that regard that you can't replead or assert affirmative defenses that go back to the heart of what we have already decided. There's no question about that. We've decided certain elements. I'm not disagreeing with you there. That I read the affirmative defenses, and they smack of relitigating exactly what this court decided in the prior decision. So at a minimum, right, your cross motion to dismiss certain affirmative defenses
I mean, I think, arguably, you're on point about that. Like, why are we doing this? We're relitigating the same things all over. These got to go. Or the ones that you listed have got to go.
So, I mean, so let's hear from your adversary, and then you have time.
Thank you.
May it please the court, this case absolutely is a morass, and this court can deal with it by dismissing the appeal because the decision below does not affect
Counsel, you asserting affirmative defenses that look to me to seek to relitigate or at least argue before the trial court below coverage issues that have already been decided against you. I don't think that's proper, right?
Well, as a substantive matter, we think that the decision that this that this court issued in 2021, which was all about summary judgment and whether the evidence substantiated a prima facie case, and then we failed to point out.
Well, your complaint was that you didn't that the policy was void ab initio because of misrepresentation, right?
That's right.
And then the cross motion, then there was a cross motion by the policy of a summary judgment saying that no, the policy is in full force and effect, and we agreed. I mean, at the end, even though the decreto seems to be different from the substance of the decision, ultimately it was the policy is in full force and effect. There is coverage, and we only give indemnity in the decreto to the Sandy and to the fire, and we didn't mention Nunez and Montefusco. So that now, with the affirmative defenses that you seek to have still here, I mean, I count, third, fourth, fifth, seventh affirmative defenses, they all touch about the same things. I mean, I looked at them, I read them, because I have them in front of me. They all talk about the same thing, that the issues were all decided in the prior decision. So why shouldn't they be dismissed?
They shouldn't be dismissed because in the prior decision was all about evidentiary sufficiency, summary judgment.
It doesn't matter, because at the end, we can sit here and debate that, but ultimately they got to win. They prevailed. There's a policy in effect. There's coverage. You got to defend, and you got to indemnify with respect to these two kinds of claims.
I certainly agree. I think I agree, Your Honor,
Great.
with everything you just said. Yes, I agree. And what it sounded like Your Honor was doing was reciting the decretal language of the prior panel's opinion, which we absolutely agree with and subscribe to. I do want to take another step.
So what does that do for you, though? What does that do to your affirmative defenses, though, if you agree with that?
That leaves our affirmative defenses open.
All of them?
All of them, because the decretal language, when it leaves them open as to indemnity, not as to coverage, as to indemnity.
But the decretal language doesn't control. It's the body of the decision that controls.
What we think what this court should do, again, if you get to the merits, and we really don't think you should, but if this court gets to the merits, we think what this court should do is harmonize the two in the decretal and the order, exactly like this court did in the Oluwatayo case, where instead of essentially correcting in a collateral posture a prior decretal to confirm to a prior decision, and it was actually about the scope of summary judgment. It was quite similar to this case in a way. What the court did was read the decisional language to conform to the order in the Oluwatayo case, and limited the scope of what appeared to be an otherwise very broad grant of summary judgment. But the best way for this court to deal with this morass is to dismiss the appeal, because the other side's substantial rights are not prejudiced.
I must say, I've taken something of a study of this subject matter the last 20 years, and I am not familiar with aggrievement ever being employed to knock an appellant out of the box based on a motion, the denial of a motion to dismiss. And I thought the Mixon case, in interpreting the Court of Appeals law on this, said that what we look at is what happened vis-a-vis the relief that was sought. If relief was denied, we don't care about the reasoning. It's the denial of the relief that's at the core of the concept of aggrievement.
Well, I don't want to get into too much of a tangle with Your Honor on aggrievement. I'm happy to talk about substantial rights and rendering the order appealable but not appealable as of right, and they still have not asked for leave to appeal. They didn't ask for it in their papers in the alternative. My friend hasn't asked for it today. The ruling below, Dorchester could have undone and still can undo trivially and unilaterally with the click of a button by refiling its procedurally rejected cross motion as a motion, and then get plenary consideration of all of its arguments. that the decision below certainly pales in comparison to the impact of some other orders that this court has held do not impact an appellant's substantial rights. And I think the one that jumps out is actually the most recent one.
You know, I got to, if I were to agree with you, let's just say he doesn't file a motion, he doesn't, and it stands with your affirmative defenses as they are. There could be the concern I have is there could be an inconsistent verdict here. You could have a trier of fact find that ultimately there's no coverage. And then what do you do then at that point? Now you've got really a morass because you've got a decision from us that says there's coverage, and then later on a trier of fact finds that there is no coverage based on your affirmative defenses. What does that leave everybody at that point?
Well, Your Honor, I want to be very...
You know what the Court of Appeals are going to like? They're not going to like that. They're like, what are you doing?
Well, of course, we're in an interlocutory posture, so that would have to wait until final judgment unless this court kicks it up. But first of all, when I think about this sort of morass that you're envisioning, I just want to make clear, we are not, at least I don't think we are, disputing coverage. I think Your Honor and I understand each other.
And you know what? Stipulate the withdrawal, and then stipulate to withdraw all the affirmative defenses that talk about coverage. Because I listed these affirmative defenses, and they say the word coverage in every single one of them. If you agree with that, and I agree, if you take that position, then you can stipulate to withdraw these affirmative defenses that talk about coverage. And
Something to think about. Thank you.
Thank you, Your Honors.
I'd like to try to illustrate the problem with the discrepancy between the decisional and the decretal provisions of this order. What it will require us to do down below before a jury is show the jury 3 documents: the disclaimer letters for the Nunez and Montefusco cases, which show that Starr had 3 coverage defenses: rescission, the concealment, fraud, and misrepresentation provision of the policy, and the protective safeguards provision.
Sir, I'm not
jury.
employing the Socratic method here. I genuinely don't know the answer. Is there a time limit to move to clarify an order within the appellate division? I know there's obviously a very rigid time limit vis-a-vis re-argument. Do you know if there's a deadline for making a motion to clarify?
A motion for resettlement, I believe, does not have a deadline. If this court believes that's the correct procedure, I move now. This court deems appeals to be motions all the time.
You know, you're going to owe us $45.
Split 5 ways.
It doesn't work like that.
The point is, I was trying to explain, what we would have to do before a jury is prove to a jury law of the case. That is a pure legal issue for the court. It's not a triable issue of fact, and that's why it's so important for this court to clarify that ambiguity.
Is it analogous to a Brill situation where maybe a party has a lockdown, clear, meritorious claim or defense to an action, but blows the Brill deadline for summary judgment? And now you get to the trial, and now the trial judge conferences the case and discusses it, and the judge says, look, there's no issue of fact here for me to try.
Right.
Is that a possible way this is going to play out? I know that would be unsatisfying for you, but...
I asked the lower court to clarify it. He said no. And then I asked for permission again to make a motion for summary judgment, and he said no. So I have no recourse but this court.
Thank you.
Thank you.
Thank you both.